Good morning, everybody. I am Rich Freer, and I teach at Emory University in Atlanta, and we're back for our second day of fun with civil procedure. And as I said yesterday, I'm especially happy to be here because this is home. I grew up down in San Diego. I went to college and law school here in California, and I took Barbary right here in Los Angeles and practiced here as well. So thanks for having me back. Now, yesterday, we did federal civil procedure. And today, it is all about California, state civil procedure. Now, we'll follow the same ground rules as yesterday. So let's work from this handout, the same handout. But today, we're going to pick it up at page 36. And remember that the handout really is a separate outline of the course. So I think you ought to read the Barbary materials, but review from this handout right here. And as we go throughout the material, there will be some blocks of text today, as there were yesterday, that we will not discuss in the lecture. And again, don't worry about that. What we're trying to do is have it in one place for you. That stuff's completely self-explanatory, easy stuff. And I don't want you bouncing back and forth to the other outlines. Just review from this document right here. Now, federal civil procedure yesterday has always been fair game on this exam, always. And so it's been tested a lot, and we have a great track record on it, and we talked about that track record yesterday. State civil procedure is a different story. This became an eligible topic in July of 2007. Up till then, it wasn't even an eligible topic. But July 2007, it became an eligible topic. But here's the weird deal. They still have not tested it. They have not hit it. Now, I think when they do, what they're going to do is give you a case, and the case is either in federal court or it's in state court, one way or the other. But they have not done the state civil procedure stuff yet. Now, still, we have some great news, though, because there are two subjects that we're going to cover today. The first one, personal jurisdiction, and the last one, preclusion. And those could come up either in federal or state court. And so we do have a track record on those two. Those have been tested a good bit, and they can put them either in federal court or in state court. So we're not completely without guidance here. Now, when the Board of Bar Examiners put state civil procedure on the eligible topic list, one of the things they told us was they wanted you to be prepared and understand the major distinctions, the major differences between federal and California practice. So as we go through this handout today, from time to time, I'm going to say put a D in the margin. And put it in the margin. D is simply for distinction. We're not going to do that on everything where state and federal is different. We're going to do it on those key distinctions. And so when you go back through this handout, those will stand out, and those are things that we really want to watch for when they start hitting State Civ Pro. Those may well be good topics for us. We're going to go about the same length we did yesterday, about 3 hours and 40 or 45 minutes, so 3 sessions of about 65 minutes each. And again, I'll wake you up when it's time to go home, just like we did yesterday. Let's go ahead and get started. Here on page 36, California Civil Procedure. Remember the first big topic? Are we in the right court? And the very first issue is personal jurisdiction. Now, let's just abbreviate that PJ. You and I are going to have to write down personal jurisdiction a bunch of times. We don't want to keep writing it out. So PJ, we're among friends. That's personal jurisdiction. Now, basic idea, and friends, this is important. This is something they've always been able to test because it can come up in federal court or state court. Now, let's take a look. Basic idea. This involves one question. There's only one thing here, so let's cut to the chase. Can the plaintiff sue the defendant in this state? That is all. We are not concerned with what court we go to in that state. That is subject matter jurisdiction. That's a totally different deal. Now, here's the analysis. Every court, every time. Here it is. Whether there's personal jurisdiction is a two-step analysis. Step one, you got to satisfy a statute. So there's got to be a state statute, for example, a long-arm statute. And number two, you got to satisfy the Constitution, meaning due process. So there's a statutory step and there is a constitutional step. Now, we have nothing but good news here. Here it is. Is this analysis, first the statute, then the Constitution, is this analysis different depending on whether the case will be filed in federal court or in state court? No. It's the same in both. Folks, it's exactly the same. So they can put this in a California federal court or a California state court. The analysis for PJ is exactly the same, word for word. First you find the statute, then you test the constitutionality. Now here's some even better news. Next point. Though both steps in that two-step analysis should be mentioned, the statute and the Constitution, one has been far, far more important on the California exam. Which one? It is the constitutional step. The constitutional step. Indeed, folks, that's really the only thing they can ask about for a reason we'll get to in just a second. The constitutional step. Now, when we talk about personal jurisdiction on the bar exam, we really mean in personam. And let's see what that means, paragraph B. In personam jurisdiction, the plaintiff wants to impose a personal obligation on the defendant. And remember this from law school. Jurisdiction is over the person, in personam, not over her property. And remember why. It's because of some contact between the defendant and the forum state. Now, we know that when we get this, the first thing we got to do, statutory analysis. We got great news here. Take a look at one. Statutory analysis, most states have a whole series of statutes that you got to know. And they allow personal jurisdiction in different situations, like personal jurisdiction over defendants who do any of these things. They're served with process in the state, domiciled in the state, do certain things like commit a tortious act or conduct business in the state. So in most states, you got to know a whole bunch of statutes. That is not true here. Bottom of the page. In California, though, the statutory analysis is really, really easy. Why? This is all we have to write down. The statute reaches the constitutional limit. The statute reaches the constitutional limit. So, folks, the statutory analysis in California is one sentence. That's all you got to put. Whether you're in a California federal court or a California state court, the first step is statute. Is the statute met? And all you got to say is the statute reaches the constitutional limit. So, we need to go over to the next page. Page 37, and figure out that constitutional limit, because the statutory limit's easy. And remember, the test is exactly the same, whether we're in a California federal court or a California state court. Word for word the same, and the statute's just one sentence. Hey, reaches the constitutional limit. Now, over to page 37, and folks, hit it with a highlighter. This we got to know. They're overdue for this. They have not hit this since 2004. Before that, they hit it 6 times in about 8 years, so we're always watching for this. They're overdue. Constitutional analysis, this is our old friend, International Shoe. Now, you do not need case names on the bar exam. I just put that there to bring back fond memories. But we do need to be able to recite this test, or at least a reasonable facsimile. So here's the test. Remember this from law school? Does the defendant have such minimum contacts with the forum so that exercise of jurisdiction does not offend, remember this phrase, traditional notions of fair play and substantial justice? Remember that? It's absolute baloney. We all know that, because there's nothing there that anyone can define. It's very open-ended. Now, next point, though this is amorphous, there are some easy cases. They rarely hit the easy ones. They haven't done this since long, long ago in the mid-90s. But if the defendant's domiciled in the forum, or she consents, or she's present in the forum when served with process, at least if she were not forced or tricked into the forum. Those are easy. Those are the traditional bases, and they almost always are going to meet the constitutional test. What we really want to be ready for, though, is this next point. The tougher cases involve lesser contact, a defendant who has a lesser contact with the forum. And the key here is to assess a set of factors under 3 headings. Notice there are 3 headings we need to talk about, and they're always done in this order. Contact, then relatedness, then fairness. Now, folks, most of civil procedure, as we know, is very mechanical, and in a lot of cases there's a clear right or wrong answer. That is not true here. Let's use the fact that this is amorphous to our advantage. There is never a clearly right answer here. So do not worry here in personal jurisdiction about getting the right answer. This is an area where folks disagree all the time. What we must do, is hit every one of the factors. That's where the points are going to be, and then just come to some reasonable conclusion. You remember, most of Civ Pro, there's going to be a right answer. Here, there's no right answer. What we got to do is hit every factor. Now, let's take them in that order. First, under A, we got to assess contact. And here's what it means. There must be a relevant contact, some tie, between the defendant and the forum state. Now, folks, these next 2 points are key. There are 2 factors to be assessed here. In figuring out whether we have a relevant contact, you got to talk about these 2 things here. Number 1, the contact must result from purposeful availment. Circle purposeful availment. That's a huge phrase. It must be in your answer. Period. End of discussion. It must be there. I mean, you know, make sure it's a personal jurisdiction question. That's where they really like it, when it's relevant. And notice what purposeful availment means. It means the defendant's voluntary act. Now, please write this in. Defendant must reach out to the forum. Defendant must reach out to the forum. You see, this contact between the defendant and the forum cannot just be an accident. It cannot be happenstance. It's got to be the result of the defendant's reaching out to the forum. She's got to direct herself to the forum in some way. That is purposeful availment. She's reaching out. She's directing her activities toward the forum. Now, there are a million ways to do this. Next question, what are examples of purposeful availment? Well, trying to make money. Trying to make money. We're trying to make money in the forum state. That's availment. Or using the roads. Sure, using the roads. That's purposeful availment. Or causing an effect. Causing an effect. We sent in some defective product or something. Anything like trying to make money or using the roads or causing some effect. Anything where you can say the defendant reached out, availed herself of the forum in some way. So the contact must result from purposeful availment of that sort. Now, we're still not done with contact. We also need foreseeability, bottom of the page. Foreseeability, what does this mean? It must be foreseeable the defendant could get sued in this forum. It must be foreseeable the defendant could get sued in this forum. Got to be foreseeable that she could get sued here in this forum. So contact, what we're looking for is some tie between the defendant and the forum, but not just any tie. It must result from purposeful availment, and it must render it foreseeable that she could get sued here. Obviously open-ended stuff. Now, let's go to the next page. We have done contact. Contact, we must talk purposeful availment and foreseeability. We've done that. Now, let's say we have a contact. The next thing we have to look for is relatedness. Now, here's what that means. Relatedness between this contact, we just said there was a contact, and the plaintiff's claim. So it boils down to this. What question do we ask? Here it is. Does the plaintiff's claim arise from the defendant's contact with the forum? Does the plaintiff's claim arise from the defendant's contact with the forum? We just said the defendant had a contact with the forum. Now, does this lawsuit, whatever it is the plaintiff's suing for, does that arise from the contact? Does it arise from what our friend the defendant was doing here in the forum? And the answer to that's going to be yes, or it's going to be no. Now, let's see how that shakes down. If the answer is yes, then the court might uphold jurisdiction, even if the defendant does not have a great deal of contact with California, with the forum. Now, where the claim is related to the defendant's contact with the forum, it is called specific PJ, specific personal jurisdiction. This is called specific personal jurisdiction, and you're going to have to tell the examiner that. So if this claim that the plaintiff is asserting against the defendant arises from the defendant's contact with the forum, what the defendant's been doing here, we call that specific PJ, specific personal jurisdiction. Now, what if the answer to that question is no, though? How about the next one? What if the claim does not arise from the defendant's contact with the forum? Well, then jurisdiction is okay only if the court has general personal jurisdiction, not specific, but general personal jurisdiction. And to have this, what must be true? Now, folks, the Supreme Court has weighed in on this for the first time in many, many years in the summer of 2011. So here's what we need to know. What must be true? The defendant must have continuous and systematic ties with the forum. Now, look at what it says. So that, and let's jot it in, defendant is essentially at home in the forum. So defendant is essentially at home in the forum. Up until the case in 2011, we're going to have general jurisdiction as long as you had continuous systematic ties with the forum. Now it's a little narrower. It's got to be continuous systematic ties so that you're essentially at home in the forum, and then you're subject to general PJ. Now, one other thing I want you to jot in here, and let's put it in parentheses before we get to the next question. You just wrote where the defendant is essentially at home in the forum. Now, in parentheses, write this. Probably also, there is general PJ. Probably also, there is general personal jurisdiction. If the defendant is served with process while voluntarily in the forum. If the defendant is served with process while voluntarily in the forum. Probably also, there is general PJ if the defendant is served with process while voluntarily in the forum. That's the traditional rule. That's always been true. We don't think the Supreme Court undid that last year. So probably if you're served with process while you're there, even if you're not essentially at home there, you were traveling there or what have you, they probably have general jurisdiction. What we really need to focus on, though, is what is that essentially at home? What's that all about? Next question, where is a human always essentially at home? Where domiciled? Where domiciled. The court made that very clear. So if you're domiciled in a state, you can be tagged there for general in personam, general personal jurisdiction, so domicile. Now, the tougher thing becomes businesses. What about businesses? Next one. Where is a business essentially at home? Well, let's jot in two things. Number one, where formed. Where formed. Where that business was formed. If it's a corporation, that's where we incorporated. Where formed. And number two, it's PPB. It's principal place of business. Remember that phrase yesterday, principal place of business? And since we're not sure how to spell principal, P-A-L-P-L-E, we put PPB. That's our shorthand. Now, the Supreme Court made that clear, that a business is subject to general personal jurisdiction. Where it's essentially at home, that means where it's formed, where it has its principal place of business. Now, here's where it's very unclear. Bottom of the page. There might be other places, too, like where the business has a regional headquarters or major production facilities, but we're not sure. We're not exactly sure. Can essentially at home be based on sales or purchases within the forum? No. No. You apparently must have a physical presence. You apparently must have a physical presence. Apparently must have a physical presence. So we're not going to get general jurisdiction over a business just based on its purchases or sales in that forum. It's got to have some presence there, some physical presence beyond. But exactly how much, nobody's sure. Nobody's sure. This is a little bit unclear about what essentially at home is all about, particularly for a business. Now, over to page 39. We know that if we are essentially at home, if there is general PJ, then here's what that means. As we summarize, top of the page. So a defendant who is essentially at home in the forum can be sued there for a claim that arose anywhere in the world. That is general PJ. But a defendant who's not essentially at home in the forum can only be sued there for a claim arising from her activities there in the forum. That is specific jurisdiction. So, for example, you are domiciled in California. So you can be sued in California on a claim that arose in California or a claim that arose in Kuala Lumpur. That's fine. You're subject to general PJ. But you have very limited ties, let's say, with Arkansas. So you could only be subject to specific jurisdiction in Arkansas. They'd have to sue you on a claim arising from something you did there. So we've done contact, purposeful availment, foreseeability. We've done relatedness. Is it general or specific? Now we got to do fairness. The third set of factors, fairness. Now we assess whether jurisdiction would be fair or reasonable under the circumstances. Friends, there are three factors to throw in here. We have no idea how to weight them. All we got to do is hit them and see the facts that relate to them. One is convenience. The defendant may complain that the forum makes it tough to litigate because it's far from the defendant's home, and maybe it's tough to get the defendant's witnesses and evidence to the forum. Defendant's always going to raise that, but look at this standard. It's really tough. The standard, the forum is okay unless it puts the defendant at a severe disadvantage in the litigation. And folks, jot this in. And the relative wealth of the parties is not determinative. The relative wealth of the parties is not determinative. We don't care about that. Defendant may well say, well, I don't have much money. Plaintiff has a lot of money. Plaintiff should have to sue here. That doesn't matter. We don't really care about that. And so wherever it is, it's very, very tough for the defendant to make this showing because relative wealth of the parties is not determinative. And it's okay unless you're at a severe disadvantage. Very tough to show. That's the old Burger King case. Remember Burger King? That was a whopper of a case. Okay, have it your way, all right? Now, what other fairness factors should we throw in? Well, there are two others, and again, we don't know how to weight these, we just throw them in. The second is the state's interest. For example, the state may have an interest in providing a forum for its citizens. Friends, always mention this and watch the facts. Watch the facts. Be on the lookout for a state interest. One time, a few years back, they had personal jurisdiction, and they made it very clear that the state had passed a statute especially about this kind of claim. So the state had an interest in providing a forum. And then the last one is the plaintiff's interest. We throw it in. Maybe the plaintiff has been injured and wants to sue at home, doesn't want to travel. Again, the key to success, don't worry about getting the right answer. You got to hit every factor and just come to a reasonable conclusion. So we got to have the summary here. Here we put it all in one place. This is solid gold. The summary of the constitutional test, here's the whole deal. You got to talk contact. There were two factors there. You got to talk relatedness. That's general or specific. And then you got to talk fairness, and there are three factors there. Now let's put it all together in a hypo. Again, the answer, who knows what the answer is? There's no right answer to these. Just come to a reasonable conclusion. Hypo, Doofus makes valves in Pennsylvania and sells them to a company in New York. So right there you got a Pennsylvanian reaching out only to New York. The New York company then puts the valves into its widgets and sells the widgets nationwide. A Doofus valve in one of these explodes here in California. So the Doofus valve got into California, but Doofus did not send it here. Is personal jurisdiction in California going to be constitutional? Well, we have no idea what the answer is. Just walk through the factors, apply the facts. First, contact. Is there a contact between Doofus, that Pennsylvania company, and California? Yes. The Doofus valve blew up here. Folks, for starters, that is okay. For starters, you gotta find some contact. Any contact at all will get the ball rolling. And here, yeah, a Doofus valve got into California. For starters, that's okay. But we're not done. Now we gotta apply those two factors. But was this contact the result of purposeful availment by Doofus of California? Who knows? What we got to do here is argue it both ways, come to a reasonable conclusion. Folks, you got to be able to argue this both ways, so let's do it. Bottom of the page, maybe the answer is no. Maybe there's no purposeful availment because it was a third party, that New York manufacturer, that sent the valves into California. Let's jot this in. Doofus sent nothing to California. Doofus sent nothing to California. It sent its valves only to New York. It was the New York company that sent this Doofus valve to California. So maybe there's no purposeful availment because Doofus sent nothing to California. So maybe there's no purposeful availment. On the other hand, let's go to the top of the next page because we can argue it the other way. On the one hand, maybe no purposeful availment by Doofus, that Pennsylvania valve maker of California, because didn't send anything to California. However, maybe the answer is yes, top of the page, because Doofus makes money from the sales by that New York company into California. Folks, maybe that is availment. Maybe that is availment. Even though Doofus did not sell it directly into California, it makes money off California. Maybe that is availment. What's the answer? I have no idea what the answer is. But neither do the examiners, because neither do the courts. If you gave this to 10 courts, they would split 5 to 5 on purposeful availment. Actually, it'd be 5 to 4. The Georgia court not sure what the issue was. All right? So, folks, don't worry about getting the right answer. Just make the argument. Same thing here. Is it foreseeable that Doofus could get sued in California? Well, maybe. If Doofus knows that its valves get into California, it knows that valves can explode and hurt people, make the argument. Just make the argument. That's all we got to do. come to some reasonable conclusion. These are not clear. Personal jurisdiction's wonderful in this regard because we don't have to worry about getting the right answer, but we do have to hit the right factors. Now, we've done contact. Number two, is there relatedness? Yeah. In fact, this is a good example. The claim arises directly from that contact between Doofus and California. So if Doofus has very little contact with California, jurisdiction might still be okay because there is relatedness. And in the margin, just write specific. Specific. This is specific PJ. This is a great example of specific personal jurisdiction because this is a claim that arises out of the defendant's contact. This may be the only Doofus valve that ever got here, but the lawsuit arises from it, so there's specific jurisdictions, what we'd argue for. Notice if there were no relatedness, we would need general PJ, and that's only going to be possible if Doofus had such continuous systematic ties with California that it's essentially at home here, and we have no facts on that. Now, we look at fairness. Reasonableness, and there are three things to throw in. First, convenience. Doofus may complain that the litigation in California is difficult and expensive because it's tough for him to get his witnesses here from Pennsylvania. But remember the standard. It's very difficult. But it has to show that it is so gravely inconvenient as to put you at a severe disadvantage in the litigation. Friends, that is almost impossible to show. I mean, it really is. Due process does not guarantee you a convenient forum. It just guarantees you one that's not unconstitutionally bad, that's all. It doesn't guarantee you a great forum, a convenient forum, just one that's not unconstitutionally grossly inconvenient. So it's not much of a standard. It's very tough to meet that kind of test. Don't forget the other fairness factors. Just throw them in, make of them whatever you think is relevant. State's interest, the forum state of California, might have an interest in providing a courtroom for its people who are harmed by allegedly careless out-of-state manufacturers. Folks, always mention that and be on the lookout, because every once in a while on this exam, they will tell you a specific state interest. Gee, this state passed a statute about defective widgets. Yeah, we really want to be able to sue those guys for defective widgets. And then the last one is plaintiff's interest. Plaintiff is hurt and would find it tough to litigate in the defendant's home state. Mention this. It's worth something. We're never sure exactly how much it weighs into the factors, but it's worth something. The most important thing I can say about PJ, bottom of the page, assess each factor, come to a reasonable conclusion. Folks, that is what we got to do, so don't worry about getting the right answer, as we said. Now, let's go over to 41. As I said, they've not hit PJ since 2004. They're overdue for it, and they have never hit PJ based on the internet. But there is some great case law, and we're starting to see this around the country now, so let's take a look at this. Special note about the internet. A Nevada hotel maintains an interactive website on which Californians can get rate information, make reservations, get driving directions from California to the hotel. Now, this supported specific jurisdiction in California over the Nevada hotel. On the other hand, notice that maintaining a passive website, though, that just provides information in another state, that is probably not a relevant contact with California. So let's jot this in. An interactive website can be purposeful availment. An interactive website can be purposeful availment. So an interactive website, sure, that may be availing yourself of the California market there, as we saw on that note. Okay? Now, I would be stunned, I mean shocked, if they asked you anything about in rem or quasi-in rem jurisdiction. I have never seen a bar exam question in any state about in rem or quasi-in rem, so take a look at that sometime when you cannot sleep, as opposed to right now, okay? So, a very unlikely area. Now, what about subject matter jurisdiction? We're in state court today. We got personal jurisdiction now, subject matter. Basic idea here, we've decided we have PJ over the defendant in California. And today we're going to sue in state court, not in federal court. There is one basic trial court here in California, and it is the Superior Court. Each of the 58 counties has one superior court. Now, friends, there has never been a question about this. They haven't hit it. This went on the exam July of 2007. It became eligible. They've never asked about this stuff. But let's see about the superior court. Paragraph B, the superior court has general subject matter, not personal. Personal jurisdiction is a different deal. We've got that now. Don't confuse that. Personal jurisdiction's over. Now it's subject matter. General subject matter jurisdiction. What does that mean? Generally, it can hear any case. It can hear any case. California Superior Court can hear any case. And that's what general subject matter jurisdiction means. So if you had a dispute between a citizen of Australia and a citizen of Canada about a car wreck in Mongolia, can that go to a superior court in Fresno? Absolutely. Yes. They can hear anything. They can hear anything at all. General subject matter jurisdiction. Next point, I think very unlikely, but are there any kinds of cases Superior Court could not hear? Yeah, but they're very, very few. There are some federal question cases that must go to federal court, but very few. And I've never seen this tested anyway. They include bankruptcy, federal securities and antitrust, and patent infringement. Those kind of federal questions must go to federal court. But outside of that, though, Superior Court can hear any case, including cases that would invoke federal question or diversity jurisdiction. Most federal questions you can sue in state court or federal court. Either way, it's up to you. Now, next up, within the Superior Court, there are different classifications of cases. Number one, limited civil cases. Let's fill in the blank. These are civil cases in which the amount in controversy does not exceed $25,000. Does not exceed $25,000. That would be a limited civil case in Superior Court. Does not exceed $25,000. Now, what if they hit that exactly? Very bottom of the page. If the plaintiff demands exactly $25,000, is that a limited case? Yes. Limited is $25,000 or less. $25,000 or less. So if it's $25,000 on the nose, that is a limited case. Now, why does that matter? $25,000 or less is a limited case. Why does that matter? Top of the next page. In a limited civil case, you get limited discovery. We'll see that later on in 58. And you also cannot file something called a special demurrer, which is not something I'd lose sleep over anyway. More importantly, though, notice that in a limited case, generally, you cannot get a permanent injunction or declaratory judgment or determine title to land. So they don't do those sorts of things. But the biggest limitation is this. If they're going to test in this area, and I'm not sure it's at the top of my list, but if they are, let's be ready for this. The biggest limitation in a limited case, no claimant can recover more than $25,000. No claimant can recover more than $25,000. So if it's a limited case, no claimant, whether it's the defendant asserting a cross complaint or the plaintiff on her original claim, no claimant can recover more than $25,000. Now that's limited. Next up, number two, unlimited civil cases. Now these include civil cases in which the plaintiff seeks general equitable relief. If you want a permanent injunction, declaratory judgment, generally that's got to be an unlimited case. But the more important point I would bet is about damages. What about a case seeking damages? Let's fill it in. It is unlimited if the amount in controversy exceeds $25,000. Exceeds $25,000. It's an unlimited case if the amount in controversy exceeds $25,000. And here, I would also write this in, any claimant can recover any amount. Any claimant can recover any amount. If we have an unlimited civil case, then the $25,000 limitation does not kick in for anybody. Any claimant can recover any amount. So that's the difference between limited and unlimited. And again, in an unlimited, any claimant can recover any amount. Now, paragraph 3, I think it's very unlikely, but small claims cases are heard, as it says, in the small claims division of the Superior Court. It's not a separate court. Procedures are real simple. And what's the amount in controversy? Well, it tells us if plaintiff's an individual, $7,500 or less. if plaintiff's in entity 5,000 or less. I don't think they're going to go small claims. Now, again, they've not hit any of this, but if they want to, it seems to me paragraph C would be a reasonable question. Classification and reclassification. Number one, plaintiff initially determines what kind of case it is. So it's up to the plaintiff to figure out, is it limited or unlimited? Now, question, in doing so, what do we consider? Well, here's what the statute says. It's the amount of the demand, or the recovery sought, or the value of the property, or the amount of the lien that's in controversy. Now, question, does this include attorney's fees, interest on the claim, or costs? No. It is the claim alone. It is the claim alone. That is where we're going to tell if it's limited or unlimited. It's the claim. It's not costs on the claim or anything like that. It's the claim itself. Now, how about this one? If the plaintiff files a limited civil case, she must note the classification in the caption on the complaint. You need not note it if it is unlimited. So in the caption right there on your complaint, it'll say complaint. And if it says unlimited, if it says limited, then it is a limited case. If it doesn't say anything, then it is unlimited. Now, reclassification. Bottom of the page, case is misclassified, or if subsequent events make it clear that the original classification should be changed, does the court lose subject matter jurisdiction? No. No. The case is reclassified. The case is reclassified. So this is a great rule. We're not worried about subject matter jurisdiction here. All we're worried about is kind of housekeeping about whether we call it a limited or unlimited case. And if we reclassify it, great, we can do that. This does not affect SMJ at all. Now, over to 43, there are two ways that reclassification can happen. One at the top of the page is automatic. And here's how that works. If the plaintiff amends her complaint in a way that changes the classification. For example, she raises or decreases the amount in controversy from limited to unlimited, or unlimited down to limited. What happens? The clerk of court reclassifies the case. The clerk of court reclassifies the case. This is automatic. It's easy. It's easy. So if the plaintiff sues for $25,000 or less, it's limited. Then she amends to go over $25,000. The clerk of court automatically is going to reclassify the case to unlimited. Now, the other way it can happen is on motion. So a party can move to reclassify. Or the court could reclassify on its own motion. But what is required here? Well, the court must give notice to all parties and hold a hearing. The court must give notice to all parties and hold a hearing. So if there is a motion to reclassify, either by a party or the court raises it itself, there's going to be notice to all parties and we're going to hold a hearing. Now, if we're going to have one of these motions, what is it the court looks at to determine whether to reclassify? Middle of the page. In determining whether to reclassify, can the court consider the merits of the underlying claim? No. No. And the way we say that is this. We will not try the case to determine classification. We will not try the case to determine classification. We're not going to determine the merits at this stage. That doesn't make any sense. This is just housekeeping anyway, by and large. And so we will not try the case to determine classification. We're not going to decide the merits to figure out whether it's limited or unlimited. So what can you look at? If you're not going to try the case to determine classification, what do we look at? Next question. Can the court consider materials beyond the pleadings, such as a judicial arbitration award, which is on page 65, and settlement conference statements? The answer is yes. It can look beyond the pleadings. Yes, it can look beyond the pleadings. We're not going to try the case to do this, but we can look beyond the pleadings. And in fact, one other thing to note, it must consider a judicial arbitration award. It must consider a judicial arbitration award. If there is one, and they'd have to tell you all about it, then you must consider that. So in granting or denying, considering one of these motions to reclassify, we're not going to try the case. The court can look at things beyond the pleadings, and it must consider a judicial arbitration award if there is one. Now, what's the standard for reclassifying? Next question. If there is a motion to reclassify, the court may reclassify, now look at which way we're going, from unlimited to limited. From unlimited to limited, when the judge is convinced that the matter, and we're going to jot in two things. Number one, will necessarily result in a verdict of $25,000 or less. Will necessarily result in a verdict of $25,000 or less. That's number one. Will necessarily result in a verdict of $25,000 or less. Or number two, more than $25,000 is virtually unobtainable. More than $25,000 is virtually unobtainable. More than $25,000 virtually unobtainable. So we have a motion to reclassify from unlimited to limited. Court will grant it if it decides either of these. Either, and these basically are two ways to say the same thing, that the matter will necessarily result in a verdict of $25,000 or less, or that more than $25,000 virtually unobtainable. Now over to the next page, what about the flip side? What if we want to reclassify the other way around? From limited to unlimited, what's the deal here? Well, if there's a motion to reclassify, the court may reclassify from limited to unlimited when the judge is convinced that, and here's what we jot in, there is a possibility the verdict will exceed $25,000. There is a possibility the verdict will exceed $25,000. That's the standard. So you have a motion to reclassify from limited to unlimited. The court will grant it if there's a possibility the verdict will exceed $25,000. And that's what's going on there. Now, friends, if they hit this next point, it seems to me, is also very testable. What are the effects of multiple claims? But it's going to be really easy. We'd love a question here. It's really easy. Look at this rule. The rule is that the entire case, the whole thing, is either limited or unlimited. So no case is mixed with some limited and unlimited. So it's got to be the whole thing is either limited or unlimited. Let's do the hypos. Plaintiff asserts 3 unrelated claims against the defendant. One plaintiff, one defendant, 3 unrelated claims. One is for $12,000, one is for $8,000, and one is for $6,000. Can this be filed as an unlimited civil case? The answer is yes. We aggregate the plaintiff's claims. We aggregate the plaintiff's claims if it's one plaintiff versus one defendant. Aggregate the plaintiff's claims if it's one plaintiff versus one defendant. So we aggregate them, and that means the amount here is $26,000. That's why it's an unlimited case. Now, the good news here is that aggregation rule is exactly the same as federal court diversity jurisdiction. We saw that on page 4 yesterday. The amount is different, of course, but if you're trying to get a federal diversity case and you're trying to get more than $75,000, if it's one plaintiff versus one defendant, we aggregate all the claims we want. Same thing here, trying to get it to be unlimited. Now, what about this one? P1 asserts a claim of $26,000 against D. And P2 asserts a claim of $14,000 against D in the same case. Can this be filed as an unlimited civil case? Yes. P1's claim is unlimited, so the case is unlimited. P1's claim is unlimited. It's more than $25,000. So the entire case, the whole thing, is unlimited. Even though that claim by P2 is only $14,000, there's no such thing as limited and unlimited in the same case. It's all or nothing. And since P1's claim is unlimited, the case is unlimited. Now, same idea if we have claims by the defendant back against the plaintiff. This next one raises that. Plaintiff sues defendant for $20,000. That's a limited civil case. Defendant files a cross complaint, we'll see those later, back against the plaintiff, and it's for $26,000. What happens? Well, the entire case is reclassified as unlimited. The entire case is reclassified as unlimited. See, the plaintiff's original claim was limited, but that cross complaint by the defendant was over $25,000. So the whole case is now unlimited. And remember what that means. That means that any claimant can recover any amount. Any claimant can recover any amount. Once you say it's an unlimited case, then any claimant can recover any amount. So even the plaintiff's original claim for 20 grand, he could win 500 grand. Doesn't matter. Once you say it's unlimited, any claimant can recover any amount. And the very last one, plaintiff sues defendant for $26,000. That's an unlimited case. D files a cross complaint back against the plaintiff for only $12,000. What happens? Well, the entire case is unlimited. The entire case is unlimited. Remember, we don't do some limited, some unlimited. The whole case is one or the other. And here the entire case is unlimited. And we know what that means. Any claimant can recover any amount. Whenever we say it's unlimited, any claimant can recover any amount at all. Now, we go to the next page, and it's time for venue. Remember, 3 hurdles we got to get over for figuring out the right court: personal jurisdiction, subject matter jurisdiction, venue. And remember, on the federal side, venue was fairly popular. So what goes on here on the state side? Basic idea now. We know that the case will be filed in state court in California, but where do you go? Well, remember, as it says, in federal court, we lay venue in an appropriate federal district. What's the relevant place for laying venue in state court? It's appropriate county. An appropriate county. So here in the state system, we're going to lay venue by county. So we're going to San Diego County, Los Angeles County, Orange County. Where are we going? What county are we going to lay venue in? Now, in state practice, there is such a thing called local actions. There is no longer any such thing as in federal court, but there is in state court. I think this is fairly unlikely. Bar exams around the country, local actions rarely show up. But let's see what it is. These are cases for the recovery of land. Circle the word land. Recovery of land. Or the determination of an interest in land. Circle the word land. We're picking up a pattern. These are land cases. Or for injury to land, circle land. Those are local actions. Those kind of land cases are local actions, and we never have to worry about this anymore in federal court. There's no such thing as a local action in federal court anymore. Now, why does it matter? Look at this. In a local action, where do you lay venue? In the county where the land lies. In the county where the land lies. So if they give you venue, don't let them slip this past you. I think it's an unlikely area, but don't let them slip it past you. Just ask yourself, is this one of those land cases? If so, that's easy. We've got to lay venue where the land lies. Now, in all likelihood, it will not be a local action. So we got to look at C. If it is not a local action, it is called a transitory action. For venue purposes here in the state, every case is either local or transitory. If it's not local, then it's got to be transitory. And here are your venue choices. General rule. Venue is okay in a county, let's jot it in, where any defendant resides when the case is filed. Where any defendant resides when the case is filed. That's a great rule. Notice they don't all have to reside in the same county. It's where any defendant resides when the case is filed. Terrific rule. Now, the way California does it is it gives you that choice. That's good in every case. You can always lay venue where any defendant resides when the case is filed. But then they give you additional choices depending on what kind of case it is. So take a look at the next one. There's an additional venue. This does not supplant what we just did. It is in addition to what we just did. Additional venue in contract cases. Venue is also okay in the county where, let's jot it in, the contract was entered or to be performed. The contract was entered or to be performed. So if it's a contract case, we can lay venue where any defendant resides when the case is filed, or in the county where the contract was entered or to be performed. Now about the next one, there's also additional venue in a personal injury or wrongful death case. Here, venue is also okay in the county where we jot in the injury occurred, where the injury occurred. So if it's PI, personal injury or wrongful death, lay venue where any defendant resides when the case is filed or where the injury occurred. That's fine. Now, these points at the bottom of the page, I think, are very, very picky. I think they're very, very unlikely. And I want you to take a look at those when you get a chance. I think they're very unlikely, too picky, especially the first time through if they were going to hit Civ Pro for the first time on the state side. Now, over to page 46, one other venue deal. We've seen the choices that we have. What if, very top of the page, what if all the defendants are non-residents of California? Well, venue is okay in any county. In any county. If all the defendants are non-residents of California, we can lay venue in any of the 58 counties here in the Great Golden State. So venue's okay in any county at all. Now remember, on the federal side, in recent years when they've hit venue, they've always asked about transfer too. So let's see what the transfer rules here are in state court. Transfer, we are moving the case from a superior court in one county of California to the superior court in another county in California. Now, there are going to be a couple of things to look at. First, if the original venue was improper, so it was not a good venue, defendant can move to transfer to a proper county. When must this motion be made? It is with or before her answer, demurrer, or motion to strike. With or before her answer, demurrer, or motion to strike. So if you got sued and it's an inappropriate venue and you want to complain about that and make a motion to transfer to a proper place, you got to do it with or before your answer, demurrer, or motion to strike. And we'll see all of those things later on. Now, how about the next one? Even if original venue is proper, the court may on motion transfer. So we can transfer away from a proper place. But here's why. Pretty limited circumstances. Number one, there's reason to believe that an impartial trial cannot be had in the original venue. Maybe there's bad pretrial publicity or whatever it is. Or the convenience of the witnesses and the ends of justice would be promoted. You know, even though this is a proper venue, that other place is a lot more convenient. Or number three, very unlikely if no judge is qualified to act. I mean, you may have counties in California. I don't think you do as many as we have in Georgia. Georgia has like 250 counties. And so we have a lot of counties in Georgia where everybody's kind of related to everybody else. Okay? Know what I mean? And there you might have a judge who's related to everybody, so you can do it. It's a fairly unlikely deal. Now, how about this? If the court grants the motion under this statute, so we're going to transfer away from a proper place, it transfers to a county on which the parties agree. Now, what if they do not agree? Then the court chooses a county. Then the court just chooses a county. That's all that's going on there. So even though the original place is proper, we may transfer for any of those three reasons there. And if we do, parties will usually agree where it's going to go. If they don't, then the court chooses a county. Now, this next point, folks, is very similar to something we saw yesterday, but they use a different term here. It's called inconvenient forum. That is what the feds call forum nonconvenience, and I don't think it'd be the end of the world if we called it forum nonconvenience here. But by statute, they actually call it inconvenient forum. So it is actually codified here. As in federal court, this is where a court dismisses or stays, because the far more convenient, far more appropriate court is in a different judicial system. You cannot transfer to a different judicial system. Now notice the example. For example, if the other court is in a state court in Missouri, you cannot transfer from a state court in California to a state court in Missouri. It cannot be done. Those are different systems. You can transfer from a federal court in California to a federal court in Missouri. That's okay, because that's the federal system. Or if it's a foreign country. So the better court, the center of gravity court, where this case really ought to go forward, is in a different system. By statute in California, state courts can dismiss or stay on motion, and it can be a motion by the party or even by the court itself. The court must find that in the interest of substantial justice, an action should be heard in a forum outside California. Now, that's kind of highfalutin language, but it basically means what we saw yesterday. The court looks to the same kind of public and private factors as we did in federal court. Jot in there page 11. Yesterday, we talked about that on page 11. This works just like it does on the federal side. It's just that we call it inconvenient forum. And then, as it says, if the court grants that motion, it may do so on condition. This is very common. For example, on condition that the defendant waive personal jurisdiction or statute of limitations objection in the other forum. Defendants are usually happy to do that because they'd much rather have the litigation go forward in Italy than here, so they may waive some defenses. Now, next big topic, we got to learn about the case. And remember, the first thing is service of process. Basic idea, the defendant must be served with process. Now, we defined this yesterday. It's the same definition. It's 2 documents, summons and a copy of the complaint. Now, very bottom of the page, who may serve process? Any non-party who's at least age 18. Any non-party who's at least age 18. That's great news because it's the same as federal court. It's exactly the same. Who can serve process in federal court and state court? Same thing. Any non-party who's at least age 18. Now, let's go over to 47. We know what process is. It's the same as it is in federal court. We know who can serve it. It's the same as in federal court. But here we're going to see some differences in the methods of service. Now, what are the choices? Remember in federal court we did personal or substituted or service on an agent. It was basically up to us. Let's see how they do it in state court. Number 1 is personal service. And that is good any place in the state, same as in federal court. Now, let's hang a star on number 2, substituted service. And this is different from federal court, which we saw on page 12, in some ways. And folks, this is the first time we're going to do this. Let's put a D in the margin. I think this is a relevant distinction. D is for distinction. We're not doing it for everything that's different between the 2 systems, but this is a relevant distinction between federal and state practice. Let's see what I'm talking about. You can only use substituted service to serve an individual, now notice, if personal service cannot, with reasonable diligence, be had. So notice, you must try personal service first, and only if that's not possible can you use substituted. Folks, that is totally different from federal court. In federal court, if you wanted to use substituted, you just do it. They were not in a preferred order in federal court. Here they are. You gotta try personal first before you can go to substituted. And then when we get to substituted, the requirements are a little more refined. Then the requirements are that it must be made at the defendant's usual abode or mailing address, certainly not a post office box, but where the guy's hanging out. That's the same as in federal court. But look at the rest of this. It must be left with a competent member of the household who is at least age 18. Remember in federal court there was no magic age. It just said suitable age and discretion. Here it's got to be somebody in the household at least age 18. And the last 2 requirements are also totally different from federal court. That person must be informed of the contents. That was not required in federal court. And process must also be mailed, first-class mail, postage prepaid, to the defendant. That was not required in federal court. So that's how we do substituted. Now, question. When is such substituted service deemed effective? It is 10 days after the mailing. 10 days after the mailing. Remember, it's not enough just to do that substituted service. You got to mail it as well here in state court. And it is deemed to be complete 10 days after that mailing. So later on, we'll see that we got to respond within 30 days of being served. That service is effective 10 days after the mailing. Now, how do we serve process on corporations and other businesses? Pretty easy stuff. We're going to deliver process to an agent for service of process or to an officer or general manager. And these folks can be served personally or process left with somebody apparently in charge at the office during usual office hours. And folks, I would jot this in. You can always serve the registered agent. You can always serve the registered agent. Every corporation is going to have a registered agent here in California. You can always serve the registered agent. That's easy enough. And you can even jot in page 12. We saw that on the federal side. We can serve the registered agent. That's usually the way to do it. We saw that in federal court yesterday, page 12. Now, service by mail, let's see what's going on here. The copy of the summons and complaint and 2 copies of an acknowledgement form, basically just a waiver form, are mailed to the defendant, along with a self-addressed stamped envelope addressed back to the plaintiff. This works exactly like the waiver in federal court. We saw it on page 12. Remember, it was waiver by mail. Except here, it's not waiver. This is actually considered service by mail. Even though it's a waiver form, it is considered service by mail and not waiver of service as it is in federal court. Now, I'm not sure that's a huge deal, but in federal court, there's no service by mail except as allowed by state law, as incorporated there in the feds, as we saw yesterday. Here, this is called service by mail. Now, there are 2 other points, very picky points. Number one, the defendant has 20 days instead of 30 days in federal court to return that form, so the timing's a little different on that. And then number two, service is deemed complete. Service is deemed complete when the defendant executes the waiver. Service is deemed complete when the defendant executes the waiver. So we sent this stuff off to the defendant. When the defendant signs that waiver form and then mails it back, when he signs it, when he executes that waiver, that is when service is deemed complete. So it's not waiver, it's actual service. Very bottom of the page, very unlikely. What about service by publication? This doesn't happen very often. It's only on affidavit from the plaintiff's attorney that the defendant cannot be served. We just can't find this guy after demonstrating reasonable diligence to serve the defendant in some other way. That's a last resort. Publication service, very, very last resort. That's not going to fly. Basically, you can do almost anything else. Now, over at 48, a little bit more to get done here. Service outside California. This is a great law here. This is a great law. If you want to serve somebody outside the forum state, this can be made out of state in any manner that's allowed by California law. Or, this is the way to do it, it's easy. Just by mail, postage prepaid, return receipt requested. That's the way you do it, it's easy. Just mail it that way. And if it is done by mail, it is deemed complete the 10th day after the mailing. Now remember, in federal court, we can use state methods for serving process. So even though in federal court under the FRCP, there is no service by mail, there's waiver by mail, but not service by mail, it's okay. We can use state methods in federal court as we saw yesterday. So they could put this in federal court and ask you about methods of service under California law. Now, paragraph E, immunity. Defendant, a non-resident, is served with process in Bakersfield while in California to be a witness or a party in a civil case. Is defendant immune from being served with process for the California state court civil case? No. California abolished this immunity. California abolished this immunity. Now, friends, that is different from federal court. Federal court, page 12, we said that if you're in the state to be a party or a witness in another case, you're immune from being served for a federal civil case, but you are not immune from being served in a state civil case. So it's different than we saw on the federal side. And if you want to put a D in the margin, that might make sense, a distinction there. This immunity is abolished in California. For California cases, it is not abolished on the federal side. Subsequent documents, just like in federal court, you can deliver them or mail them. If you mail them, add 5 days to the time required for response, 10 days if it's out of state. That's different. In federal court, it was just 3 days, and I think that's awfully picky stuff. Now, folks, let's just spend a minute on this. Let's get into pleadings. Oh, sure, we could break now, but I know what'll happen. Somebody will say, hey, I want to get into pleadings. Okay, let's just get into it. Basic idea, the timing and some of the terminology are different from federal court. All I want to do is get through paragraph B. I think paragraph B about frivolous litigation, we'll get through and take a break. Let's take a look. There are 2 general statutes here in state practice. Remember, on the federal side, all we worried about was Rule 11. Here it is on the state side. Number 1, California has a statute that mirrors Federal Rule 11. It works exactly like Federal Rule 11. And we saw that on page 13 of the handout. There's only one exception, and it's minor. Here it is. Here's the difference from federal court. That 21-day safe harbor applies not only in motions brought by a party, but also when the court raises the issue on its own. So if the court thinks you violated Rule 11 and raises that issue on its own, in state court, the court has to give you that 21-day safe harbor. Well, if you fix the problem within 21 days, then there cannot be any sanctions. In federal court, that safe harbor did not apply when the court raised it. Now, look at number 2. This is a better statute. There's another California statute that allows the court to order a party or his attorney or both, attorney or both, to pay the expenses and attorney's fees incurred by another party, now look at this phrase, because of bad faith or frivolous tactics in litigation. I would circle in litigation. The bad faith, the frivolous activity has to be related to this litigation, not in the real world generally, but in this litigation. Now, we like this statute because this is a monetary sanction. We want to get monetary sanctions from that guy, and you can do it here. Remember, Rule 11 is usually non-monetary sanctions, but here, monetary. Now, what is frivolous? Frivolous means, as it says, something completely without merit. They raise something completely without merit, or for the sole purpose of harassing an opposing party. And folks, let's write this in. There is no safe harbor. There is no safe harbor here. You can file this motion immediately. Remember, on Rule 11, you cannot. You got to serve it on the other side, give them 21 days safe harbor before you file the motion. But here, on this one, there is no safe harbor. You can file that motion immediately. And as it says, there must be a motion by the party or the court and an opportunity to be heard. Folks, I think we need a safe harbor from the lecture. Let's take a break.
Ladies and gentlemen, will you please be seated? The lecture will resume in 2 minutes.
Okay, everybody, we are back, and we're at the bottom of page 48, and we're talking about pleadings here in state court. And as we're going to see, there's going to be some terminology that's radically different from federal court. But one thing that's the same name in both is, of course, the complaint, and that's the next point. Now, the standard, however, that we have to meet is different. Take a look. The complaint, California has always followed what is called fact pleading. Remember on the federal side, we talked about notice pleading and plausibility pleading. Here it's called fact pleading. And here are the requirements. The contents, this is all we need in our complaint. A is a statement of facts. Let's circle that word. It's called fact pleading, so you got to have facts. Constituting the cause of action. And again, on the state side, we tend to say cause of action, not claim. Federal court, we tend to say claim, not cause of action. Stated in ordinary, concise language. Now, folks, please write in 2 words on those blanks. Ultimate facts. Ultimate facts. In California, when you're pleading your facts, what they want are the ultimate facts. Now, it is impossible to define ultimate facts. It is not impossible, however, to spell it. And so I think if we simply know that phrase, we're okay. They don't want every factual detail. They want the ultimate facts, and I think those words ought to be there. Now, over we go to 49. In addition to the ultimate facts that show our cause of action constituting the cause of action, we also have to make a demand for judgment for the relief to which the pleader claims to be entitled. What do you want? Do you want damages, injunction? What do you want? So, notice what it says. There are 2 main parts to the complaint. What about these particulars, though? Question, must the plaintiff allege subject matter jurisdiction? No, absolutely not. Now, we did in federal court, but that made sense. Federal courts have limited subject matter. They can only hear certain kinds of cases. That's not true here. So we do not have to allege subject matter. Now, how about this next one? I don't have any idea why I put a blank after this sentence, but let's see it. Remember that the complaint in a limited civil case must state that it is limited. And there's a blank there. I guess you can put, okay. I'll remember. I mean, okay. So it's supposed to have that in the caption of the case. Big deal. Now, this gets kind of interesting. How about this next one? If the plaintiff seeks damages, must she state the amount? Generally, yes. Generally, yes. So in state court, you want damages, generally you're going to give them a dollar figure. Folks, I would hang a star on this exception number 1, and when we get to it, exception number 2. Exception number 1, in what kinds of cases is the plaintiff, get this, forbidden from stating damages amount in the complaint? It is personal injury and wrongful death. Personal injury and wrongful death. So ordinarily, they want you to state a damages figure, a dollar figure. But if it's personal injury or if it's wrongful death, you cannot. It's not that you should not. You cannot have a dollar figure there. It's forbidden. Now, the second exception, also important. We hang a star on exception number 2 also. Whenever the plaintiff claims punitive damages. In any case where you're asking for punitives, she is forbidden from stating the amount in the complaint. And folks, I would jot in there any case. In any kind of case, doesn't have to be personal injury, wrongful death, in any kind of case where you're asking for punitive damages, you cannot give a dollar figure there. Now, that puts the defendant in a tough spot, doesn't it? Because the defendant's been sued and there's no damages figure, so we don't know how big this case is exactly. So let's take a look. So in a personal injury or wrongful death case, how can the defendant find out about the amount of actual damages? And anytime there's a claim for punitive damages, how does the defendant find out about the amount? Defendant requests a statement of damages. Defendant requests a statement of damages, and after you write that out, in parentheses, just call that an SOD. SOD is our shorthand for statement of damages. So the defendant requests a statement of damages, and then one other thing to jot in, plaintiff must provide it within 15 days. Plaintiff must provide it within 15 days. So you get sued in one of these cases, and you say, wow, man, I'm trying to figure out how big a deal this is. You can request a statement of damages. Plaintiff has to tell you that within 15 days. Now, look at the text. If the plaintiff fails to provide the statement of damages, defendant can move for a court order requiring the plaintiff to do so. Also, very bottom of the page, another time we'll have an SOD. In a personal injury or wrongful death case, and any time the plaintiff seeks punitive damages, what must the plaintiff do before you take the defendant's default? You must serve an SOD, statement of damages, on the defendant. You must serve an SOD, statement of damages, on the defendant, even though he doesn't ask for it. This is default. So if there is a default in one of those kinds of cases, personal injury, wrongful death, or in a punitive damages claim, if there's a default, you gotta, before you can get the default, what you're going to have to do is give them notice of that. You got to give them the statement of damages before you can do that, before you can take the default. And that is by statute, of course. Now, over we go. Page 50. Paragraph 2, top of the page, I'd put a D over in the margin. This is a good distinction from the pleading requirement in federal court. So, remember the requirement of fact pleading here in California. Now, what does that mean for the plaintiff? Here is a great phrase. She must allege the ultimate facts on each element of each cause of action. She must allege the ultimate facts on each element of each cause of action. Must allege the ultimate facts on each element of each cause of action. So you got to be pretty precise. You got to go through the law here. What are the elements of battery or whatever this claim is, emotional distress, whatever it is. And you got to give out the ultimate facts on each element of the cause of action. Remember in federal court back on page 14, we had to give facts supporting a plausible claim. A little bit different terminology. Number 3, there are heightened pleading requirements where you got to give more detail. And the big one is circumstances constituting fraud. I would circle fraud, and they must be pleaded with particularity. We saw the same thing in federal court. If you're going to go for fraud, you got to give detail. The rest of that, very unlikely, it seems to me. So must these. In California, you got to give details on civil conspiracy, tortious breach of contract, unfair business practice, etc., etc., etc. So the list is longer, but for bar exam purposes, we're always looking for fraud. Friends, what about paragraph 4, fictitious defendants? I would hit it with a highlighter. California is very well known for this. And one of these days, they got to test this. This is great stuff. If the plaintiff is genuinely unaware of the identity of a defendant, she may name the defendant as a Doe defendant. Just Doe. We don't know John Doe, Mary Doe, Jane Doe. Now, that's not enough. She must also allege that she is unaware of the defendant's true identity, and she must state a cause of action against the Doe defendant. That's called a charging allegation. It's got to be there. Now, you might say, how can this ever happen? How do you not know the defendant's identity? Well, here's a good example. Plaintiff, while walking in the crosswalk, is hit by a car driven by D1. D1 had been rear-ended by a car driven by D2, which knocked D1's car into the plaintiff. After the wreck, look what happens. D2 flees. He had been driving a stolen car. Plaintiff sues D1 by name, and we sue D2 as a Doe defendant. Plaintiff also alleges she's unaware of D2's true identity, states a charging allegation against D2. Is that okay? Yes. D2 is a fictitious defendant. D2 is a fictitious defendant. This is a great example of that. You just don't know who this person is. And so we go ahead and sue. We want to get this thing on the book. So we go ahead and sue, name him as a Doe. Go ahead and say that you don't know, you cannot figure out who it is, and state the charging allegation. Now, why is this going to matter? Look at the next point. Fictitious defendants may come up with the statute of limitations issues. We're going to see that on page 56, and we will refer back to it here. And as we will say there, I think it's a very testable issue, but we know what these fictitious defendants are all about. Now, number 5, verified pleadings. These are pleadings that are signed under oath by a party. Now, they are rare, but they are required, for example, in shareholder derivative suits and in suits against government entities. Now, if they ever tell you about verified pleadings, and I think it's unlikely, but if they did, remember this point. Remember that verified pleadings can be treated as affidavits. Now, why would that matter? Summary judgment. It could matter for summary judgment. As we saw yesterday, regular old pleadings are not evidence, so you can't use them on summary judgment, at least not for evidentiary purposes. But if it's a verified pleading, hey, that's under oath. Treat it like an affidavit. Now, next up, folks, let's hit it with a highlighter. Defendant's response. This is going to be different, big time from federal court. The defendant must respond in an appropriate way within 30 days after the service of process is deemed complete. Remember, in federal court, it was 21 days. So right there, we see a timing difference. Now, I got to tell you, frankly, through the years on the federal materials, this exam has not been very picky about timing. They've not done a lot about timing. But this one, 30 days instead of 21. The bigger deal is this. Remember in federal court when we got sued, it was real easy. We responded by motion or by answer. That was it. We had 2 choices. That was it. Here, we got a ton of choices. Here's the deal. I think very testable, although, again, they've not gone there yet. One possibility is the general demurrer hangs stars all over it and put a D in the margin because there is no such thing as a demurrer in federal court. They do not exist. A general demurrer. This can be used to assert some defenses, but which is the most important? It is failure to state facts sufficient to constitute a cause of action. Failure to state facts sufficient to constitute a cause of action. That is the major use for the general demurrer, and I would be on the lookout for it. It is failure to state facts sufficient to constitute a cause of action. Now, this terminology is different from federal court. Remember, in federal court, we just said failure to state a claim. Here it is a general demurrer, failure to state facts sufficient to constitute a cause of action. But the good news is, over on 51, it works just like a 12b6 over in federal court. It works the same way as a motion to dismiss, failure to state a claim. It just has different terminology. So the terminology matters. But luckily, the functions are the same as what we saw yesterday. So top of 51, this is like the federal motion to dismiss for failure to state a claim. We saw it on page 29 yesterday. So the court takes factual allegations as true, limits our assessment to the complaint and anything that we take judicial notice of, And if it's sustained, usually the court will let the plaintiff try again. So it has the same function as that failure to state a claim. Now, next point, watch for this to test the substantive elements of a cause of action. Friends, watch for a crossover with anything. Watch for a crossover with anything at all, because they can test you on the elements of any tort, any contract claim, anything this way. They can say, well, there's a general demurrer that's filed, and have we stated the elements of a claim for ultra-hazardous activity or whatever? Watch for a crossover. They can ask you any substantive elements of any cause of action. How about this? What else could be raised by general demurrer? Well, it's lack of subject matter jurisdiction, lack of SMJ, subject matter jurisdiction. But folks, that's almost never going to happen in state court. Remember, state courts generally can hear anything, so that's just not a big deal. If you get a general demurrer, it is going to be about that failure to have our cause of action laid out. Next up, can these defenses be raised in the answer instead? Yes. Affirmative defenses. They would be affirmative defenses. So if you want to raise that, failure to state the cause of action, you want to raise subject matter jurisdiction, you can just plug it in the answer as an affirmative defense. That's okay. Or, in this next point, I think quite unlikely, but it could be a motion for judgment on the pleadings if it's raised after the defendant has pleaded and the time for demurrer has expired. We saw that same phrase on the federal side. It was basically a 12b6 if you'd already answered. That's what you would call it. Next question, is a general demurrer considered a pleading? Yes, yes. But it's kind of odd because it acts like a motion. It acts like a motion because you're trying to get the case dismissed. So it acts like a motion, but it is a pleading. So when we talk about how to amend pleadings, it will apply to your demurrer. When we occasionally see a rule that says you may plead within X days, that would include a demurrer. So yeah, it is a pleading, although it acts like what we call a motion over on the federal side. Now, general demurrer I would always look for along the lines we talked about. Special demurrer, folks, I think is very, very unlikely. This can be used to assert many very, very, very minor defenses. These are just not big deals. Let's see what they are. You can raise any of these by special demurrer. The complaint is uncertain, ambiguous, or unintelligible. Well, that's like the federal motion for more definite statement. You can jot in there page 14. We saw that yesterday, and I said I've never seen it on a bar exam. Very unlikely. Or the complaint's unclear about which theories of liability are asserted against each of the defendants, or lack of legal capacity, or the existence of another case between these same parties on the same cause of action, defect, misjoinder of parties, failure to plead whether a contract is oral or written. Any of those can be raised by special demurrer. And then bottom of the page, failure to file a certificate of merit could be raised by special demurrer. Now look how precise this is. Certificate of merit, this is required to sue architects, engineers, or land surveyors for professional negligence. In such cases, the plaintiff's attorney must file a certificate certifying that she has consulted with a professional and there's reasonable cause to file the case. Folks, this is very limited. This is not for all professional malpractice. It's only for architects, engineers, land surveyors. That's the only kind of case for professional negligence that you're going to have to file this. And lack of certificate of merit can be raised by special demurrer, or, bottom of the page, lack of certificate could be raised by a motion to strike that we'll see on 53. So these are pretty minor defenses. You could raise them by special demurrer. Top of 52, can these various defenses, all those minor ones we just saw, could they be raised in the answer instead? Yes. By affirmative defense. Yes, by affirmative defense, except the failure to file certificate. Except the failure to file certificate. That one you're going to have to raise by special demurrer or motion to strike. But all the other ones, you can do special demurrer or just stick it in your answer as affirmative defense. So yes, affirmative defense, except that failure to file the certificate. Now, next question, what happens if these defenses are not raised by demurrer or by answer? Well, they're waived. They're waived. So you got to put them up or else you lose them. So you put them up in a special demur or in your answer, or else generally they're going to be waived. They're gone. Now the special demur, notice it works kind of like a general demur. As with the general demur, the court treats the allegations of fact as true. And we limit assessment to what's in the complaint and matters of judicial notice. Question, is a special demur considered a pleading? Yes. Yes, it is. And a limitation here, when are special demurrers not available? Well, it's in limited civil cases. In limited civil cases, remember $25,000 or less, there is no special demur. But folks, again, I think special demur, very unlikely stuff. They want to go the demur route. I'm watching for the general demur, failure to state facts sufficient to constitute a cause of action. Terminology. Well, notice that motions are either granted or denied. But what about demurrers? They are sustained or overruled. They are sustained or overruled. So technically, when we make a motion, the court either grants or denies it. If we make a demurrer, technically the court either sustains or overrules it. And again, I'm not sure I'd stay up till 4 o'clock worrying about that, and I mean 4 in the afternoon. It's just that if you see that, I don't want that phrase to throw you. Sustained is the same as grant, overrules the same as deny, and if you remember the phrase, we should probably say it that way. Now, next up, number 4, absolutely yellow magic marker moment, the motion to quash service of summons. Put a big old D in the margin. This is a huge distinction because there is no such thing as this motion on the federal side. Motion to quash. This can be used to assert what defenses? Let's number them. Number 1, lack of PJ. Lack of personal jurisdiction, PJ. Number 2, improper process. Number 2, improper process. Remember, process was 2 documents, summons and a copy of the complaint. If there was a problem with one of those documents, that's improper process. And number 3, improper service of process. Improper service of process. So if any of those 3 are true, either lack of PJ or improper process or improper service of process, you're going to raise it by a motion to quash service. Now, in capital letters, write, this is a special appearance. This is a special appearance. When you make a motion to quash service of summons, based on any of those 3 there, that is a special appearance, and I think that's got to be in your answer. It's a big deal. If you want to gripe about personal jurisdiction, improper process, improper service, it's got to be a special appearance. That means this motion to quash service of summons. Now, the timing, huge. Look at this. This motion must be made before or with. Before or with. Never after. Before or with a demur, answer, or motion to strike. Or else the defendant waives these defenses. So you got the motion to quash, make sure you raise it before or with demur, answer, or motion to strike. Now, folks, look at this hypo. This is going to come out radically different in state court from federal court. Good hypo. Plaintiff sues defendant. Hey, they all start like that when we think about it. Defendant files an answer in which he asserts the affirmative defense of lack of PJ, personal jurisdiction. That would be okay in federal court. That's okay. You've preserved it because defendant raised personal jurisdiction in her first Rule 12 response. So you're okay in federal court. But in state court, defendant has waived the defense of lack of PJ. Why? Because an answer is a general appearance. An answer is a general appearance, and it waives these 3 defenses. Those 3 we just listed up there, you cannot raise them in your answer. An answer is a general appearance. You cannot raise any of these 3 that we listed above, lack of PJ, improper service, improper process. You cannot raise those in your answer. Cannot do it. You can in federal court, but not here. Because an answer is a general appearance, and if you want to raise these, it's got to be a special appearance. Got to be the motion to quash. So radical difference, California, very old terminology and very old rule here. Answer is a general appearance. It waives those 3 defenses. You cannot raise those 3 in your answer in state practice. Now, over to page 53. We know that if we want to raise any of those three, it's going to be in a motion to quash. We got that. Going to make a special appearance. Now, what about this one? Top of the page, plaintiff sues defendant. Defendant files a motion to quash service of summons at the same time as the demurrer, answer, or motion to strike. Is that okay? Yes, that's okay. That is okay. That is not a general appearance. That is not a general appearance, so you're okay there, as long as you do it at the same time. But, folks, do not put PJ in the answer. Remember, PJ, improper process, improper service of process, you cannot put it in your answer. That's going to waive it. You got to have it in the motion to quash special appearance. Next point, if the court denies your motion to quash, the defendant must plead within 15 days. Now, remember, a demurrer is a pleading. So after your motion to quash is denied, you could demur within 15 days because a demurrer is a pleading. Now, this next point, very, very, very important, I think. I would watch for this. I think it's very testable. I would hit it with a highlighter. If the court denies your motion, you made a motion to quash, special appearance, you made the motion to quash and it's denied, there is only one way to get appellate review. And you must seek what's called a writ of mandate from the Court of Appeal within 10 days. So you cannot wait until final judgment to raise that issue in the Court of Appeal. In the margin right next to that, jot in page 70. On page 70, we're going to talk about that writ of mandate. Folks, it'd be a great question, because not only do you have to know about the motion to quash, you also got to know that the only way to get appellate review from a denial is the writ of mandate. Page 70. We'll get there sometime, about midnight. It'll seem like it. Now, there's another defensive response. What about number 5, motion to dismiss or stay for inconvenient forum? It's a motion for inconvenient forum. Remember, that's what we call forum nonconvenience. Now, here's the timing. What is the timing for bringing this motion? It is waived if it's raised after a demurrer or motion to strike. It is waived if it's raised after a demurrer or motion to strike. So if you have a motion on inconvenient forum, and remember we're asking them to dismiss or stay the case, if you're going to do that, it's waived if it's after your demurrer or motion to strike. Now notice one other thing here. You can raise this after your answer. You can raise this after your answer. So if you answer, you have not waived the motion for inconvenient forum. But if you demur, or if you bring a motion to strike, you have waived the motion for inconvenient forum. Very picky stuff. Then there is the motion to strike. Here, a party can file this to strike all or part of any pleading, and the court may strike irrelevant, false, or improper matter. Please write in there page 14. On page 14, we saw the motion to strike on the federal side. Same idea here, and very, very rarely tested. Next up is a very special motion to strike, and California is pretty proud of this. Let's see what it is. It's called the anti-SLAPP motion to strike. Anti-SLAPP. Now, let's see what's going on. The legislature is concerned about, look at what it's called, strategic lawsuits against public participation. That's SLAPP, strategic lawsuit against public participation. These are suits that are brought to chill the valid exercise of First Amendment rights, like the right of speech or the right to petition the government. So you sue me to get me to shut up. That's what you're trying to do. When the plaintiff sues the defendant for an act the defendant took in furtherance of or First Amendment rights, defendant can make an anti-SLAPP motion to strike. Now, why is this a big deal? Notice why defendants love this, very bottom of the page. The defendant must make a showing that the plaintiff's cause of action arises from protected activity. Look, you're suing me because I testified to the government about how much pollution your business puts into the atmosphere, something like that. You're suing me for protected activity. If the defendant makes this showing, check this out, what happens? The burden shifts to the plaintiff to show the probability of winning on the merits. The burden shifts to the plaintiff to show the probability of winning on the merits. That's pretty tough. And defendants love this because now, even before we get to trial, we're going to force the plaintiff to show probability, not possibility, probability of winning on the merits. So defendants love this because to avoid the striking of the case, that plaintiff has to come up with all that evidence. Now, over to 54, these motions have been abused, and so, of course, the legislature has to step in to cut back on them, and here it is. Because so many anti-SLAPP motions were made, the legislature limited the availability of the motion. So, defendant is not supposed to make this motion if the plaintiff's case is truly in the public interest or on behalf of the general public. Let's jot this in. This is really the standard. The motion is inappropriate. The motion is inappropriate if the plaintiff is enforcing a public right. The motion is inappropriate if the plaintiff is enforcing a public right, not just a personal, selfish right, but a public right. So if this lawsuit against me for my mouthing off to the government officials, if that really is a case brought by the plaintiff enforcing a public right, I should not be able to make the anti-SLAPP motion. That's the standard. Motion inappropriate if the plaintiff's enforcing a public right. Now, how about this one? Let's say the defendant wins her anti-SLAPP motion. Now, she can sue the person who sued her. And that claim is for malicious prosecution, and that's called a slapback suit. So you sued me because I was mouthing off to the government. I bring an anti-SLAPP motion. I get your case stricken. And then I can sue you for malicious prosecution. And it goes on and on. And that's kind of a hassle, but it employs more lawyers. We like it, all right? Now, what about the answer? Well, finally, something that's like federal court. It's just like the answer in federal court. Same name. There could be a general denial. I think it's very unlikely. It's a very short document, one sentence. General denial, short document, in which the defendant simply denies each and every allegation of the plaintiff's complaint. It's permitted, but remember, if the defendant can do so consistent with the rules about frivolous litigation. If you, in good faith, can deny everything, then do it in one sentence. Not a big deal. You can do it in federal court, too, but they're very rare. Now, in stating affirmative defenses, be careful to state the ultimate facts. State the ultimate facts sufficient to constitute an affirmative defense. State the ultimate facts. Remember when we talk about facts in state court, it's got to be ultimate facts. Always throw that in. Ultimate facts sufficient to constitute an affirmative defense. You know, ordinarily on the federal side, we just say state the affirmative defense. Here, we're going to do it much more wordily. It's a wordier deal in state court. Ultimate facts sufficient to constitute an affirmative defense. How about this one? If the plaintiff filed a verified, remember that's under oath complaint, then the defendant must file a verified answer. And they've got to tell you that. And remember, if you got verified pleadings, you can treat them like affidavits. They are treated like affidavits because they're under oath. But they got to make that obvious. Question, can an answer include a demand for recovery back against the plaintiff, for example, for damages? The answer is no. You need a cross complaint. You need a cross complaint. So you cannot demand recovery from the plaintiff in your answer. You're going to need a separate document, and we're going to see it in a minute, called the cross complaint. Timing. And again, they've just not been very sexy about timing in the federal court stuff. But the timing here, and they've not hit the state stuff as all as we know, no later than 30 days after service of process is deemed complete, the defendant must, to avoid default, file an answer or a demur or one of those motions that we noted. But a motion to strike will not extend the time in which to demur. Very picky stuff there. And again, they just have not gotten very sexy about the timing stuff at all through the years. Now, what about claims by the defendant? Friends, let's hit it with a highlighter. And let's put a D in the margin for distinction. And luckily, the only distinction is going to be terminology. They're going to function just like in federal court. But let's see what's going on. Claims by the defendant, as in federal court. The defendant can assert a claim. Now remember, there are three of these. One, back against the plaintiff. That's against an opposing party. Or two, against a co-defendant. Or three, against an impleaded third-party defendant. In federal court, those three claims had three different names. They were the counterclaim, they were the cross-claim, and they were the impleader claim. And remember how we remembered that? They started with C, counterclaim, cross-claim. They were between parties who were already there. Counterclaim is defendant against the plaintiff. Cross-claim is defendant against co-defendant. Starts with I, you're bringing in somebody new. That's impleader, bringing in the third-party defendant. Now, check this out. In California state courts, all three of these claims have the same name, and they are called cross-complaints. Cross-complaints. So in state court, friends, there is no counterclaim. There is no cross-claim. There's nothing we call an impleader claim. You gotta call it cross-complaints. So at one level, it's easier because they all have the same name. So that's great, cross-complaints. And notice that the cross-complaint must be a separate document from the answer. It is separate from the answer. Remember, in federal court, a counterclaim was part of your answer. Here, they're going to be a separate document. Now, let's walk through the three. The terminology is different, but what's great is the function is exactly the same as those claims in federal court. Let's check it out. Bottom of the page, we got the cross-complaint against the plaintiff. This is exactly like the federal counterclaim, except it's not part of your answer. It's a separate document, and it's to be filed before or at the same time as the answer. Now, let's go over to the next page and see the characteristics of the cross-complaint back against the plaintiff, and it's all good news because we already know all this from the federal counterclaim. This claim is against an opposing party, so defendant back against plaintiff, somebody who sued you. Question B, what if the cross-complaint against the plaintiff arises from the same transaction or occurrence as the plaintiff's cause of action against the defendant? It is compulsory. It is compulsory. So, folks, it's the same as the compulsory counterclaim we saw on page 16. It's the same idea. So if somebody sues you and you have a claim back against her arising from the same transaction or occurrence, it is a cross-complaint here in state court, but it's compulsory. You must assert it here. Cannot sue on it separately. Works just like the compulsory counterclaim. Now, what about C? What if the cross-complaint by D against P does not arise from the same transaction or occurrence as the plaintiff's cause of action? It is not compulsory. It is not compulsory. And you treat it like the permissive counterclaim. You treat it just like the permissive counterclaim. Remember we talked about counterclaims on page 16 yesterday. So if somebody sues you, you have a claim back against her, it does not arise from the same transaction or occurrence as her claim, you may assert it here. It is a cross-complaint, but you do not have to. What about number 2, cross-complaint against a co-party? Well, this is just like the federal cross-claim. May be filed any time before the court has set a date. And we did cross claims on page 16 yesterday as well, so it's the same thing. It's a claim against a co-party by a defending party. It must arise from the same transaction or occurrence as the underlying dispute, but remember, see, it is never compulsory, ever. The party may assert it here as a cross-complaint or may sue in a separate case, so it works just like a cross-claim. And then, number 3, there's the cross-complaint against the third-party defendant, TPD. This is exactly like federal impleader, third-party complaint. Can be filed any time before the court has set a trial date. And remember, it is never compulsory. No such thing as compulsory impleader or compulsory cross-complaint against the TPD, so you don't have to file it. Now, folks, I'd jot in a couple of words there. Indemnity or contribution. Indemnity or contribution. Remember, that's why we file this claim against the third-party defendant. We're joining somebody new. She's never been a party before, but she owes us indemnity or contribution on that underlying claim, and you can jot in page 25. We talked all about that there. So it works just like federal court. It's just that we have different terminology. And what is the other good news here? Well, we don't have to worry about subject matter jurisdiction here, do we? You don't have to go through diversity federal question supplement. You don't do that at all because the whole case is either limited or unlimited, as we saw before. Number 4, the person against whom any cross-complaint is asserted must do what? Well, she must respond within 30 days. She must respond within 30 days. You are essentially a defendant now. You're a defendant on that cross-complaint. So you're going to have to respond within 30 days, and you might have an answer, a motion to quash, whatever it is you're going to raise, but respond within 30 days. And then number 5, if the cross complaint is asserted against somebody who has not yet appeared in the case, it must be served with a summons, and I would just jot in there like impleader. It's just like impleader that we saw on page 25. You're bringing in somebody new, you're going to have to serve a summons on that party. You're going to have to bring them before the jurisdiction of the court. Now, next up, what about amending pleadings? Well, notice number 1, a little bit different from the federal side. I'm not sure this is the most important thing in the world, but the plaintiff has a right to amend, or amendment as a matter of course, before the defendant files an answer or a demurrer. After the demurrer, but before the hearing on the issue raised by the demurrer, any party has a right to amend once. So that's the right to amend. And it's a little different from the federal side, but they've not tested that even on the federal side in recent times at all. Now, top of the page, what about number 2? Any party can seek leave to amend anytime, and the standard is exactly the same as in federal court. Just jot in page 18. Page 18. So that's nice. Somebody moves for a right to or leave to amend, go ahead, do the same thing as in federal court. How about number 3? Amendment to conform to the evidence is available. We were all hoping so, and it is available. Jot in there page 18. We did that there. So a lot of this exactly the same as on the federal side, which is great. Number 4, after sustaining a demurrer or granting a motion to strike, the court will usually do so with leave to amend. And all that means is we allow the plaintiff to try again. So if the plaintiff sustains a demurrer, grants a motion to strike without leave to amend, then the plaintiff cannot do it. So with leave, you get to try again. Without leave, you do not. Number 5, relation back. I would hang a star on it because this has been the biggest deal in amendment on the federal side. Remember, they hit it in July of 2011, for example. Relation back works just like it does in federal court. Jot in pages 18, 19. Pages 18 and 19 works the same way. Remember why relation back matters? We get around the statute of limitations, and so that's great. They could ask that in the state court as easily as on the federal court. Now, friends, if they get into amending and relation back, my money is on number 6. I'd be ready for it. We mentioned it before. It's about the fictitious defendants. This would be a great question, because this is just classic California stuff. Relation back and fictitious defendants. Relation back is okay if, 3 things. A, the original complaint was filed before the statute of limitations ran. It contains charging allegations against the fictitious defendants. Please write in there page 50. We had a nice hypo about fictitious defendants on page 50. B, the plaintiff is genuinely ignorant of the identity of the Doe defendants. And C, P, pleaded that ignorance in the original complaint. Now, folks, let's jot this in. I think this is good stuff. If the plaintiff amends to substitute the true defendant, if the plaintiff amends to substitute the true defendant within 3 years of filing, it relates back. If the plaintiff amends to substitute the true defendant within 3 years of filing, it relates back. What a great rule. So plaintiff amends to substitute the true defendant. We found out the guy's name. Now we're going to substitute him by his real name. If you do that within 3 years of filing, it relates back. And remember why that matters. It gets you around the statute of limitations. That's why you want to sue that Doe defendant. Get it on the books. Name him as a Doe defendant. Do all the rules there. Then, if you find out who it is within 3 years after filing, you substitute him through amendment, and you're protected on the statute of limitations. I think that'd be a good hypo for him to raise. What about discovery? Well, paragraph A, are there required disclosures? No. No, we just do not have them in state court at all. We had them in federal court. We do not have them in state court. But we do have the same discovery tools that we had in federal court. So discovery tools. Here's the timing. I think very unlikely. Plaintiff must get a court order to take discovery from the defendant within 10 days after the defendant was served with process. 20 days, though, to take the defendant's deposition. And again, I just don't think they're going to go there on the timing. I got to tell you, one of the great things about timing in state court is so many of these rules end in a 0. So many of these timing rules are 10 or 20 or 30 days. And what's great about that is what? Well, if you remember it, terrific. If they hit it, I don't think they will, but if they hit it and you remember it, great. If they hit it and you don't remember it, you just practice writing a 20 so it also looks like a 30 and a 10, and you're going to be fine. We're going to be okay with that. Now, what are the discovery tools? Well, one, of course, is the deposition. And just like in federal court, it can be oral or on written questions. And this is good news. It's the same as in federal court on all the basics we saw yesterday. What is different from federal is very minor. I just don't think they're going to go there. But there's no presumptive time limit on a depo here in state court. Federal court, it's 1 day of 7 hours, unless the court orders or the parties agree otherwise. Also, state court, there's no presumptive limit on the number of depots to be taken in the case. Federal court, there was. It was no more than 10 unless the court orders or the parties agree. So basics are all the same. Now, we go over to the next page. What about interrogatories? Well, interrogatories, here's some more good news. They are the same as in federal court on the basics. So remember, they can only be sent to parties. You never send interrogatories to non-parties. They only go to parties. Now, here in state practice, there are form interrogatories approved by the Judicial Council. And there's no limit to the number of form interrogatories that can be served on the other parties. So you can just go online, get these things formed. There's no limit to the number of those. But folks, you don't want to do that. Why? Because we're going to be billing by the hour. We want to write these, and we want to take our time, okay? So, yes, I told you, professional responsibility, my lowest grade. So, what happens if we actually want to write out our own interrogatories? Well, here's the deal. If a party wishes to draft specific interrogatories to serve on the other party, so not use the form stuff, let's write our own. The interrogatories may not contain subparts. And what is the maximum number of drafted interrogatories that are allowed in an unlimited civil case? It is 35. 35. Now, we got like 6 lines there, so that cannot be the whole answer. So we got to write in something else. It's 35, but let's jot this in. You can serve more with a declaration supporting the need for more. You can serve more with a declaration supporting the need for more. You can serve more than 35, but it's got to be accompanied by a declaration supporting the need for more. And then the other thing to write in here, the responding party can seek a protective order. The responding party can seek a protective order. So ordinarily, unlimited case, we're not going to send more than 35 interrogs, but if you want to go over that, you can. Just send them 50 or 80, whatever you want to send, but you got to have a declaration supporting the need for more. Then the burden's on the other side, the responding party, to go seek a protective order. That's how we work the numbers. Number 3, request to produce. In state court, they are sometimes called inspection demands. It means exactly the same thing. Those are interchangeable terms, but if you see inspection demand, don't let it freak you out. All it is a request to produce. And it's just like the request to produce in federal court, same thing. If it's regarding electronically stored information, ESI, you're going to specify the form desired. Do you want it in hard copy? Do you want it in e-copy? However you want it. That's the same thing in federal court, too. Now, question, is there a statutory limit on how many of these can be served without court permission in an unlimited civil case? No. No, there is not. No limit on that. Now, this next hypo, I like, and let's put a D in the margin. It's going to be different from the way we do it in federal court. In federal court, these requests to produce can be used to get information from a non-party if they're accompanied by a subpoena. We saw that yesterday. But the basic California statute does not address using these requests to produce to get information from a non-party. Nonetheless, it is possible to get discovery of things like documents or ESI. You can get this stuff from a non-party, but how do you do it? Folks, you take the non-party's deposition. Take the non-party's deposition and serve her with a subpoena duces tecum. And serve her with a subpoena duces tecum. So you're going to take the non-party's deposition and serve her with a subpoena duces tecum. We saw that phrase yesterday. We said we'd have to spell it today. How do we spell duces tecum? It is D-U-C-E-S. Duces is D-U-C-E-S. New word tecum is T-E-C-U-M. T-E-C-U-M. We saw it yesterday, and we said it's Latin for, hey, bring the stuff with you. So here in state court, it's a little more convoluted. Instead of just hitting them with a request to produce and a subpoena, here you're going to have to notice the non-party's deposition, serve that person with a subpoena ducis tecum. That means she has to show up at the depot with the documents or the ESI or whatever it is, and that's how we're going to do it on the state side. Now, there is a little statutory exception to that. Take a look at the text. For business records, if all you're after is business records, you can just subpoena those without taking a depo. So if business records, that's easier. You don't have to go through the charade of the deposition. Now, number 4, the medical examination. Let's put a D in the margin. There's going to be one difference here that I think we should flag right here. The medical exam is the same as in federal court. So you have to get a court order just like in federal court, except in one case, and this is a great rule. Except in state court, in one kind of case, the defendant has a right to demand a physical examination of the plaintiff. What is the kind of case? It is personal injury. It is personal injury. In a PI case, personal injury case, you do not need a court order. The defendant has a right to have a medical examination taken of our friend, the plaintiff. So personal injury case, that's a nice rule, and it's only in the state court, not in the federal court. Federal court, we're always going to need that court order. Over we go to 58, some little fine-tuning about this, not a big deal. At the top of the page, if we're going to have that medical exam, this sounds like fun. In California, if it's a physical exam, the lawyer for that person has the right to attend the exam. Hey, that'd be fun. If it's a mental exam, the lawyer can attend only if there's a court order allowing it. Now, other basic discovery tools, the request for admission, same as in federal practice. Now, question though, what is the maximum number of requests for admission that can be served on a party in an unlimited civil case? Folks, it's the same as interrogatories. Just jot in same as interrogatories, and we saw that on page 57. It's exactly the same. We don't want to write it all out because we already did that. It's 35. If you want to do more, you can do more with a declaration supporting the need for more, and then the other side, ask for a protective order. You treat it exactly like we did interrogatories. Little exception to that, there's no limit on the number of requests to admit genuineness of documents. Those, there is no limit on the number. Now, next up, number 6, discovery in limited civil cases. Remember, those are $25,000 or less. Folks, I think this is very unlikely. I cannot imagine the first time they hit state practice it's going to be a limited case, but let's just run through it. There are strict limits on the use of discovery devices in limited cases. First, how many depositions can a party take? 1. That's it. You only get 1 depo per limited case per party. Second, how many interrogs, inspection demands, and requests for admission can each party propound to another party? It's a combined total of 35. A combined total of 35. So you can mix up those any way you want. You could do all 35 interrogatories if you want, and then none of the others, but it's up to you. Combined total of 35. And then what about this one? In a limited civil case, can the parties ever get additional discovery? Only with a court order. Only with a court order. So pretty limited in the limited case. Now, much, much likelier is number 7. Supplemental discovery in unlimited cases only. Friends, I'd put a D in the margin. This is different from the way we did it in federal court. Unlike in federal court, there is no standing duty to supplement your discovery responses, as long as the information you gave was accurate and complete when you gave it. Remember, in federal court, you had to police your stuff, make sure changing circumstances didn't change the answers. We saw that yesterday on page 21. Different here. Instead, the requesting party can propound a supplemental interrogatory, and that elicits later required info bearing on answers previously made. And you also can propound a supplemental demand for inspection. And that demands inspection of later required or later discovered documents or things. So there is no duty to police your own answers and police yourself and supplement your responses. It's up to the other side to ask you for the new stuff. Now, bottom of the page. How many times Can a party propound a supplemental interrogatory or a supplemental request for production? It is twice before the trial date is set. Twice before the trial date is set, and once after that. And once after that. So twice before the trial date is set, and then once after it's set, you can do this. So after that trial date is set, as you're getting close to trial, before you go to trial, you're going to want to find out, is there any new stuff? Is there anything I should know about? Anything change? And you could do that with the supplemental responses, or supplemental requests there. Over to 59, the scope of discovery. And remember, on the federal side, this was fairly well tested. The standard is this: we can discover anything relevant to the subject matter involved in the pending action. Now, this is slightly broader than the federal standard. Federal standard was relevant to a claim or defense. This is relevant to the pending action. I don't think that's testable at all. The key word here is relevant. Relevant is the big word. And we had it in federal court, and we have it here. And that ties in with number 2. Folks, hang a star on it. We saw it yesterday, too. Discoverable is broader than admissible. Anything reasonably calculated to lead to the discovery of admissible evidence. Jot in there page 21. It's exactly the same as in federal court. And remember, we said, gee, admissibility is not the test. So if the other side says, I object, this would not be admissible at trial, that doesn't matter. That's not a good objection. Discoverability broader than admissibility. Number 3, as in federal court. We love it when it's the same as federal court. Privileged matters not discoverable. And when a discovery request would intrude on privileged matter, confidential communication between attorney and client, for example, the responding party must object with particularity, or else you risk waiver, and you're going to provide the court with a privilege log. Jot in page 22. We talked about the privilege log yesterday. If you claim privilege or work product, you're going to do it with a privilege log demonstrating what the communications, from whom, to whom, when, why it's protected, and so forth. Privacy. Notice that the California Constitution recognizes right of privacy, and that can be claimed to limit discovery, but it's not absolute. So a lot of discretion. Question: how does a court determine whether to allow discovery? It balances the need for the info against the need for privacy. It balances the need for the information against the need for privacy. It's just up to the court. You know, some of this discovery stuff can get awfully personal. And you might be tempted to say, hey, come on, TMI on this thing. I don't want to tell you that stuff. And maybe there's a privacy right there that'll block it. But again, it's totally up to the court. Balance the need for the info against the need for privacy. Work product. We hit it with a highlighter. We hang a star on it. We loved it in federal court, and we love it here. In federal court, it can be generated by the party or any representative of a party, and not just by attorneys. Now, put a D in the margin. This is a big distinction. Is the rule the same in California courts? No. It must be generated by the attorney or her agent. It must be generated by the attorney or her agent. So it's a different deal. In federal court, it can be generated by any rep of the party, private eye, anybody, or by the party herself. Here, it's got to be by the attorney or her agent. So she could have a private eye do it, but it would have to be as her agent. So that is why in state court, we do call it attorney work product. Federal court, we do not call it attorney work product, it's just work product. But here, it is attorney work product. Now, beyond this, it works basically just like it did in federal court. So a writing that reflects the attorney's impressions, conclusions, opinions, legal research, you never get that. Remember, that was absolute. And a pro se party, remember what that means? She's representing herself, does not have a lawyer, can generate work product if it would have been work product if done by an attorney. So if you're representing yourself, even though you're not an attorney, you can still generate work product if it would have been work product for an attorney. Expert witnesses. Let's put a D in the margin. We do this differently. I'm not sure this is all that likely because they haven't done anything with this on the federal side. But any party may request the simultaneous exchange of expert witness information. So you got to request it simultaneously, and then each party must exchange a list of experts to be called at trial, declare the nature and substance of the testimony, and give your experts qualifications. So it's easy enough to do it here. A little bit more about it on page 60. We're just going to have this simultaneous exchange of information. And then you can also demand reports by the expert. What's the expert saying about this case? And a party can take her deposition. Once you get the report, you're going to want to take the depo as well. If a party does not exchange this info, the court may exclude its expert from testifying. And all of that is about an expert who's going to testify. Here, very unlikely, but how about it? Generally, can you discover info of a consulting expert? Not an expert witness, but a consulting expert. And that is one who will not testify at trial. And the quick answer there is no. Consulting experts, no, you're not going to get that. So if you just hired an expert to consult with, not going to be testifying at trial, generally no discovery there. Enforcement of the discovery rules. Remember this, on the federal side, we had the one-step and the two-step. Number one, parties generally must meet and confer to work out problems before seeking court order. Same idea on the federal side. A party failing to do that, subject to monetary sanctions. And look what the monetary sanctions make sense. They're expenses, including attorney's fees, that are incurred by the other side because you failed to meet and confer. Now, it's a little more general here than it was in federal court. Number two, California prohibits misuse of discovery. And that's just exactly what it sounds like. Not playing by the rules, making unjustified objections, abusive motions, failing to confer, just not playing by the rules at all. By statute, the court can sanction anybody, including attorneys and parties and the attorneys, anybody who's guilty of misusing the discovery process. The person to be sanctioned must be given notice and a chance to be heard, which makes perfect sense. Now, remember the sanctions yesterday? Well, here's the list. This is going to look familiar. The sanctions include this: monetary. The monetary sanction is expenses, attorney's fees incurred by the other side because of your abuse, your misconduct. Look at the rest of these. Establishment order, refusal to allow you to support your position with evidence, strike the pleadings, entering default judgment against the defendant, or dismissing the plaintiff's cause of action. Folks, what are those? Those are the Rambo sanctions. We saw those yesterday. They're the same. They're the Rambo sanctions. We saw them on page 23. All that stuff about establishment order and all that sort of stuff. Hey, that's Rambo sanctions. We knew that from page 23. Now, the only little nuance in California is this. The court will usually start with monetary sanctions. That's where it's going to start. And it's going to move through that hierarchy of Rambo sanctions as warranted, but it has very broad discretion in selecting the appropriate sanction. Court's going to look at all kinds of stuff, including whether the abuse was willful. But California, they like to start with the monetary sanctions before they start doing all that Rambo stuff. Question: when a party seeks sanctions for discovery abuse, what must it indicate in the motion? The type of sanction sought. The type of sanction sought. So if you're going for a discovery abuse thing, that's great, but you got to tell them what you want. Do you want an establishment order? You want an order saying the guy cannot produce evidence at trial? Anything, you go ahead and lay it out there. Doesn't mean you're going to get it, but you ask for it. Number three, party can seek a protective order. Let's circle that phrase. Protective order, we saw it yesterday, a protective order to protect against unwarranted annoyance, embarrassment, oppression, burden, or expense. Folks, same as in federal court. Jot in page 22. Same as in federal court. Anytime a discovery request is overburdensome, overly intrusive, of course you can seek a protective order. And very bottom of the page, a party can object that electronically stored information is not reasonably accessible because of undue burden or expense. Maybe those files have been deleted. But you got to identify the categories of sources that are not accessible. Same in federal court. That's exactly the same as in federal court. They both handle ESI the same way there. Now, over to 61. Let's get halfway through 61. It won't take long. But we want to do it because we got I words there, and we love I words. Now, the third big topic How big does our case get? Complex cases joining parties. We got great news here. Look at paragraph A, proper plaintiffs and defendants who may be joined. It's basically the same as in federal court, page 23. It's exactly the same thing. How great is that? We love it. How about B? Necessary and indispensable parties. That's who must be joined. It's the same as in federal practice. Jot in page 24. I like it when it's the same. And then remember the I words. And there are three of them here: impleader, intervention, interpleader. And as we said yesterday, the only one we've seen tested in the last generation was impleader. Impleader, remember I words mean we're joining somebody new. The most important, the only one they've tested since Ronald Reagan was president, is impleader. And remember, that is called a cross complaint here in state court. You don't call it impleader, you call it a cross complaint. Jot in page 55, we did that. And then, as we said, intervention, self-explanatory, interpleader, self-explanatory. Read those when you get a chance. So, we've done impleader, intervention, interpleader. Those are I words. But my favorite I word right now is intermission. All right, let's take a 10-minute break.
Ladies and gentlemen, will you please be seated? The lecture will resume in 2 minutes.
Okay, everybody, we're back for our last go-round with CivPro. Again, thanks for putting up with me 2 long days on this stuff. And we're here on page 61, middle of the page, the class action. Well, we're always looking for the class action, so let's hang a star on it. And let's put a D in the margin because we do it radically different from the way we do it in federal court. Class action, always looking for. And the state statute uses vastly different language than the federal rule. So here are the requirements. If you get it in state court, here's what you do. The California statute speaks of this. It says this, kind of highfalutin language. When a question is one of common or general interest of many persons, and it is impracticable to bring them all before the court, then one or more may sue or defend for the benefit of all. Now, that's highfalutin language, and rather than memorizing that, here's what I think we should do. What does the state requirement mean? You must show, number one, an ascertainable class. You must show, number one, an ascertainable class. And number two, a well-defined community of interest. A well-defined community of interest. Those are the 2 basic requirements, and that's what we talk about here. It's far less rigid, far less mechanical than on the federal side. Here, you got to have an ascertainable class and a well-defined community of interest. Now, we need a little more detail on that second requirement here, so take a look at the bottom of the page. In considering if there is a well-defined community of interest, the court will look at whether, now let's jot in 3 things, whether, number one, common questions predominate. Whether common questions predominate, that's number one. Number two, the representative is adequate. The representative is adequate. And number 3, the class will result in substantial benefit. The class will result in substantial benefit to the parties and the court. The class will result in substantial benefit to the parties and the court. So, to get a class, we got to have ascertainable class and well-defined community of interest. To figure out whether we have a well-defined community of interest, the court considers whether the common questions predominate, whether the representative is adequate, and whether the class will result in substantial benefit to the parties and the court. Now, over to page 62, we've got the basics down for our class action here in state court. Now, top of the page, what about types of class actions? Remember, in federal court, there were 3 types of classes. What about in state court? There are no separate types. There are no separate types. There's just a class action. That's all there is to it. There is no type 1, type 2, type 3. No, not at all. There's just the class action. That's all there is in state practice. Now, what about this one? Notice, number 3, notice may be given to the class by publication. Individual notice is not required. Remember, in federal court, for the type 3 class action, you had to give individual notice, but that's not required here. Here's another difference. In federal court, the cost of the notice is borne by the representative. But how about in state court? Well, the court decides who will pay. The court decides who will pay. It's up to the court. And so it might be the rep, or it might be the defendant, or it might be that they share it. It's up to the court to figure out who pays for this notice. And it might be the rep who pays for it, it might be the defendant who pays for it, or they might have to share the expense, but it's totally up to the court. Remember, that's different from federal court. Federal court, there's no discretion here. The rep had to pay for this notice, but here the court decides who pays. Maybe the rep, maybe the defendant, maybe they share it. Number 4, all class members who do not opt out are bound by the class judgment. But check this out. Opt out may be allowed by the court. It's up to the court. Remember, in federal court, in the type 3, there was a right to opt out. Less clear here. Number 5, California does not require the court to appoint lead counsel, a class counsel. On the federal side, we did have to appoint class counsel. Number 6, settlement or dismissal must be approved by the court. Folks, this is the same as in federal court. This is the same as in federal court. Remember, if you want to settle or dismiss a class action, you cannot do it by yourself. Either in state or federal court, the court has to approve. Now, the only thing left here is figuring out the amount for whether it's limited or unlimited. Look at number 7. Determining the amount in controversy. All right? Suppose a class has 26,000 members, each of whom has been harmed $1. What is the amount in controversy for determining whether this is a limited or unlimited case? It is $26,000 because we aggregate all class claims. It is $26,000 because we aggregate all class claims. So you're going to add them all up, and here it's 26,000, so that's an unlimited case. That's different from federal court. We didn't aggregate nothing in federal court. You looked at the rep, and the rep's claim had to exceed 75,000 for a diversity case. Here it's different. We're going to aggregate all of those class claims. Now, we're done with how big is the case. 4th big topic, adjudication. Now remember, we might be able to adjudicate without going to trial. Pre-trial adjudication. And one way to do this is voluntary dismissal. Remember, we flagged this on the federal side, and I said it was tested once long ago, and there was a nice little issue they could raise. I think it's much less likely on state court because there's less they can ask you about. Look at this. Plaintiff can move to dismiss anytime before the trial starts. So anytime before the trial starts, you want to pull the plug on your case, move to dismiss. The decision is for the court to make. It's up to the court. Now, is such a dismissal without prejudice? That is also up to the court. That's totally up to the court. So this is different from federal court. Federal court, you had a right to dismiss without prejudice once and so forth. Here, it's just up to the court. Now, what happens if you move for this after the trial starts? Bottom of the page. If the plaintiff moves for voluntary dismissal after the trial starts, well, it may be granted only with prejudice, unless the parties stipulate otherwise, or the court finds good cause to dismiss without prejudice. So that is a fairly unlikely scenario, it seems. Let's go over to 63. What about involuntary dismissal? Well, a lot of ways this might happen. All courts, federal courts, state courts, every court, has the authority to dismiss for failure to prosecute. So you got a case, you file it, but you're not keeping the feet to the fire. You're letting it languish. You're failing to prosecute. Or failure to abide by court orders or by rule. And of course, for the various reasons that can be raised by demurrer, motion to quash, etc. All of those dismissals, for example, for lack of personal jurisdiction, all of those are involuntary dismissals. Now, California state courts have discretion to dismiss, now notice the timing, if the case has not been brought to trial or the defendant's not been served with process within 2 years of the filing. Now remember, dates always matter. So if that case has not been brought to trial or we haven't served process within 2 years, discretionary dismissal. Folks, I would hang a star on this next one. Mandatory dismissal. Put a D in the margin. There is no such thing quite like this on the federal side. In California state courts, the case must, circle the word must, it must be dismissed if, and we're going to jot in 2 things. Number 1, not brought to trial within 5 years of filing. Not brought to trial within 5 years of filing. Now, in parentheses, please jot this in. There was a California Supreme Court case about this just last year. So in parentheses, put this. Exclude the time when all proceedings were stayed. You exclude the time when all proceedings were stayed. Exclude the time when all proceedings were stayed. So the first one we put there is, you got to dismiss it if it's not brought to trial within 5 years of filing. But you exclude the time when all the proceedings were stayed. So if the court had said, there's a total stay, nothing can happen in this case, that doesn't count toward your 5 years. But they'd have to make that obvious. Or number 2, the second one to jot in. Number 2, if process is not served within 3 years of filing. If process is not served within 3 years of filing. So we file this case and we don't get process served within 3 years of filing, they must dismiss. Now let's put something in parentheses here, and I think this is less likely, but go ahead and put it in parentheses. We just said process is not served within 3 years of filing, parentheses, exclude the time when a stay affected service. Exclude the time, do not count the time when a stay affected service. So if the court entered a stay saying we cannot do certain things in this case, and it was something that affected your ability to serve process, then that doesn't count toward your 3 years. On the 5-year deal, you're only going to get to exclude time if there was a stay on everything. So we excluded the time when all proceedings were stayed. But that rule is pretty strict stuff. You got to get to trial within 5 years after filing that case, unless there was some stay in the meantime. Paragraph C, default judgment. Again, on the federal side, we said we've never seen it tested. It's all here for you. I want you to take a look at it on the state side on your own when you get to that. We go over to 64. Other ways to get rid of a case, involuntary dismissal. Well, there's our old friend at the top of the page, the failure to plead facts constituting a cause of action. Now, instead of Federal Rule 12b-6, remember that was a motion to dismiss, failure to state a claim. In state court, how does the defendant usually raise this? It's a general demurrer. This is a general demurrer. Jot in page 50. We did that on page 50. General demurrer is the way to go there. Good stuff. General demurrer. Then there's our friend, the motion for summary judgment. And the standard here, this is great news, is exactly the same as in federal court. We did this yesterday on page 30. And remember, there's no dispute on a material fact. Somebody's entitled to judgment. Now, we did a hypo yesterday with 3 permutations on it that had evidence being produced and presented on a summary judgment motion. Take a look at this hypo here. Here's another way to raise summary judgment. The elements for plaintiff's cause of action are W, X, Y, and Z. Under the substantive law, she must prove W, X, Y, and Z. After discovery, defendant moves for summary judgment and shows that the plaintiff has no evidence to support element X. Now, what if the plaintiff does not proffer evidence on element X? The court may enter summary judgment for the defendant. The court may enter summary judgment for the defendant. And this would be the same thing in federal court, too. It's kind of an interesting hypo, because ordinarily, in summary judgment, we are producing evidence from both sides. Here, we didn't produce any evidence to bring this motion. We are pointing out that the plaintiff does not have any evidence. Well, that's great. If the plaintiff doesn't come up with something, the court may enter summary judgment for the defendant. And the good news there is all we're doing is applying the same standard we saw in federal court. Paragraph 1 and paragraph 2 on summary judgment are details about how you bring it and when you bring it here in state court. Take a look at that when you get a chance. I just don't think they're going to get into that timing stuff. It's all there for you. Roman numeral 2 about case management. This is all text for you to look at when you get a chance. The bottom of this page and over to the next page. Let's declare victory and go to the next page. Remember, I want to create one document from which I want you to review. You don't have to go back to the CMR and the big outline. Don't want to do that. I want it in one place for you, but you can read this as well as I can. On 65, let's go down toward the bottom of the page and get to trial. We are finally up to trial. Paragraph A, what about recovery at trial? So, in her complaint, the plaintiff claims damages of $100,000. Does that limit the amount she can recover if the case goes to trial? No. She can recover whatever the evidence supports. She can recover whatever the evidence supports. And folks, that's the same in federal court. If we go to trial, your complaint is not a cap. So if you ask for $100,000 and you show damages of $1 trillion, you get $1 trillion. True in state court, true in federal court. If we went to trial, you get whatever the evidence supports. Now, one little nuance, next point. Remember, though, in limited civil cases, no claimant can recover more than $25,000. No claimant can recover more than $25,000. And remember, a case is either all limited or all unlimited. And if it is a limited case, no claimant can get more than $25,000. Now, we go to jury. Jury trial. Bottom of the page, the right to a jury. Well, there's some good news here. The California Constitution grants the right to a jury trial, and it's largely along the same law and equity split as the Seventh Amendment. We did the Seventh Amendment yesterday on page 32. Remember, it only applies in federal court, not here in state. But it's basically the same under the Cal Constitution. Some matters are handled differently, though. Now, let's go over to 66. Folks, I'd put a D in the margin here for these two hypos at the top of the page. All the way through, the halfway through this page, we're going to have D's in the margin here. Because even though under the California Constitution you have a right to a jury at law, not at equity, but at law, so it's the same idea as federal, there are a couple things we do differently, and I think this is very testable. You get a jury to determine each fact relating to causes of action at law, but not equity. Okay? So far it's just like federal. If the case involves both law and equity, the jury determines the facts on the law cause of action, and the judge determines the facts on the equity cause of action. Okay, so far it's just like federal court. But, unlike federal court, generally here, we try the equity cause of action first. We try the equity cause of action first. So we're going to try all those facts underlying the equity cause of action to the judge first, and then you try the law stuff to the jury. So the equity cause of action goes first, the judge decides the facts on the equity cause of action, then you try the facts underlying the law claim to the jury. And so remember, in federal court it was just the other way around. Federal court, the jury went first. Here, the equity cause of action goes first. And this is kind of confusing, but it's called the equity first rule. That's actually not confusing, because that's exactly what it is. It's the equity first rule. Okay? Now, a better distinction is this next one. This, I think, is very testable. Plaintiff's complaint states an equity cause of action for an injunction against future trespass and also seeks incidental damages. Friends, let's circle the word incidental. That's going to be really important. We're after damages, and that's law, that's legal relief, but it's just incidental damages for past trespass. In federal court, there is a right to have the jury determine the facts relating to damages. You always get a jury to determine your facts underlying your law claim. But what about in California state courts? There is no jury at all. There is no jury at all in this case. No jury at all. Why? Because the damages are merely incidental to the equity cause of action. The damages are merely incidental to the equity cause of action. Here we get no jury on anything because the damages claim is not a big deal. The damages cause of action is merely incidental to the equity cause of action. This is called the equity cleanup doctrine. The equity cleanup doctrine, that the judge in equity will decide all the facts, even on the damages claim. Even on all the damages stuff, the judge will decide it here in state court. And again, what you do is just say, well, if the damages are merely incidental, I mean, the case is really not focused on damages, then you do not get a jury here in state court. Federal court, you always get a jury on the legal stuff. Always, always, always get a jury on the facts underlying your law claim, your damages claim, no matter how incidental it is. But here, if it's incidental, no, the equity cleanup doctrine says no jury. Number two, requirement of a demand. Well, you do have to announce the demand for the jury at the time the case is set for trial, or within 5 days after notice of the setting of trial. So you got to make the demand. Usually it's going to be in something called the case management statement, which was on page 64, and I cannot believe they're going to go there. Failure to demand constitutes a waiver. Same thing in federal court. You got to make the demand, and the timing on the federal court we saw yesterday. Now let's fill in the blank. How about number three? What's the number of jurors? In state court, there are 12. Fill in the blank with 12 jurors in civil cases, unless the parties agree in open court to a lesser number. Remember, in federal court, you could have as few as 6, but here you got 12. And if a juror is excused for illness or other reason, an alternate juror takes her place. We do have alternate jurors here. We did not in federal court, but we do here. And if there is no alternate, the trial can go on unless a party objects. Selection. In the voir dire process, each party is entitled to 6 peremptory challenges. Remember, in federal court it was 3, but with the same idea here. And unlimited challenges for cause. So we're getting rid of potential jurors for cause, unlimited strikes of those folks. Now, how about this one? Peremptory challenges may not be used on the basis of race, color, religion, sex, national origin, sexual orientation, or similar grounds. This is broader than in federal court. Remember, in federal court, it was race and gender. You had to have a race and gender neutral reason for using peremptory challenges. We are much more protective in state court here. You cannot engage in your peremptory challenges to exercise this kind of discrimination on any of those bases. In federal court, page 32 yesterday, it was race and gender. Those are the only two the Supreme Court has talked about for the federal court situation. Over to page 67, if we have a jury, the jury's going to come back with a verdict. So the verdict in federal court, the jury verdict must be unanimous, unless the parties agreed otherwise. Now, in state court, what is required, all you need is 3/4, 3/4 of the jurors. That's all you need, is 3/4 or 3/4 of the jurors. So, since there are 12 jurors, you got to get 9. You get 9 of the 12. You do not need unanimity. In federal court, you need unanimity. Now, if we're going to control the jury, remember yesterday we saw how to control the jury with JMOL and RJMOL and all that great stuff. Well, the good stuff here is it works basically the same, but it is different terminology. Number 6 is the motion for directed verdict. This is exactly the same thing as what the federal courts call the motion for judgment as a matter of law. Remember the cumbersome, dumbass federal name, JMOL? But the standard's exactly the same. Reasonable people could not disagree on the result. Parties can move for this. Now notice, technically in state court, if you're going to move for this, technically you can only move at the close of all the evidence. Remember in federal court you moved after the other side was heard. Here, technically you make this motion at the close of all the evidence. But you can do the same thing earlier. Take a look. If the defendant moves for this at the close of plaintiff's opening statement or at the close of the plaintiff's evidence at trial, it is often called a motion for non-suit. A motion for non-suit. Now again, this is one of those where I don't think you need to lose sleep over it, except I just want you to be familiar with it in case you see it. If you see non-suit, don't let it throw you. It's just directed verdict. It just happens to be that the defendant moved for it before the close of all evidence, at the close usually of the plaintiff's evidence. Now, number 7 is the motion for judgment notwithstanding the verdict. This, in state court, is often called JNOV. That comes from a Latin phrase, judgment non obstante, something or other. I don't know how to say it because I took Spanish. But I know how to spell it. It was JNOV. And this is exactly what the federal courts called renewed motion for judgment as a matter of law. Jot in page 33. It's the same thing as RJMOL. We saw it yesterday on page 33. Standard is the same as directed verdict. So the court's saying a jury reached a conclusion that reasonable people could not have reached. That's exactly the same as in federal court. Timing on this, timing in state court is really kind of convoluted. You must file the notice of intention to move either before entry of judgment or the earlier of these, 15 days from the mailing or service of notice of entry of the judgment, or 180 days after the entry of judgment. That gets very, very convoluted. And for a state that has not done much with timing, even on the easy federal stuff, this seems fairly unlikely. Now watch for this. This is different from the feds. The party making this motion for JNOV is not required to make the motion for directed verdict at trial. That's different from federal court. Page 33 yesterday we saw that. In federal court, if you want to move for RJMOL, you must have moved for JMOL at an appropriate time of trial. So maybe that means if they're going to hit this, maybe it means it's more likely on the federal side, because you do have that prerequisite, and here you do not. Motion for new trial. Hey, this is the same as in federal court. Timing is the same as JNOV. We saw that about 1.5 inches above here. Bases are exactly the same as in federal court. Remember, something convinces the court that the party should retry the case. We should start over. And it's proper, here's the technical standard, if the court concludes that the error complained of has resulted in a miscarriage of justice. Remember what this is. It's a do-over. We're going to start over. We're going to try this case over. So maybe it comes out the same, maybe it comes out differently, but it's a do-over. It's a mulligan. Same as in federal court, page 33. Now, there are all kinds of grounds for a new trial, as we saw yesterday, as we just mentioned. Let's focus on one in particular. Now, when the Board of Bar Examiners added state civil procedure in July of 2007 as an eligible topic, they gave a list of stuff that they expected you to know about, and this actually was listed, what we're about to do here and on the next page. Now, bottom of the page, one ground for new trial is excessive or inadequate damages. What is the standard for ordering a new trial on this ground? The damages figure shocks the conscience. The damages figure shocks the conscience. It's either shockingly high or shockingly low. So if the jury came back with a figure that's shockingly high or shockingly low, that may be a basis for a new trial. Let's start over. Let's do the trial over. Now, over to 68, and let's look at this, because again, this is something they mentioned by name when they added state civ pro as an eligible topic. So we could order a new trial because the damages are shockingly off, shock the conscience. But to avoid the new trial, because the new trial is kind of a hassle, I mean, we've got to go through all that stuff. To avoid it, the court might offer or suggest remittitur or additur. And the Board of Bar Examiners actually listed remittitur and additur as subjects they want you to know about. So here it is. Remittitur sounds like remit, and that's exactly what it is. We are playing hardball with the plaintiff. Plaintiff suffered minor damage, but the jury awarded $200,000, shockingly high. The court finds the damages figure shocks the conscience, so it can order a new trial, or it can try to avoid the new trial by offering remittitur. Now, here's what it does. This gives the plaintiff a choice. Either he takes a lesser amount, which the court will state, or he's got to go through a new trial. He might not want a new trial because he might not win nothing. Now, question, is remittitur okay in state and in federal court? Yes, sure, that's absolutely great. So he wins $200,000. Court says that's shockingly high. We're either going to have a new trial unless you take, I don't know, $30,000. And the plaintiff has to figure out what he wants to do. And he might take it, might demand the new trial. Now, question, can the court simply lower the figure as determined by the jury? No. It must give plaintiff the choice. No. It must give plaintiff the choice. The judge cannot simply change the damages figure. That ain't never going to work. So you offer to the plaintiff, either take $30,000 or we got a new trial. That's it. Now that's remittitur. That's hardball with the plaintiff. Next up is additur. And here we're playing hardball with the defendant. Now here's how it works. Plaintiff suffered very serious harm, but the jury awarded only $30,000. The court finds that damages figure shocks the conscience. It can order new trial, or it's going to offer additur. Now here's what this does. This gives the defendant a choice. Either pay a greater amount in damages, which the court sets, or go through a new trial. Might not want the new trial, might lose $1 trillion there. Now, is additur, get this, is additur okay in state and in federal court? It is okay in state court. It is okay in state court. But folks, it is unconstitutional in federal court. It is unconstitutional in federal court. Wow. Now, how can it be unconstitutional in federal court and okay in state court? It violates the Seventh Amendment. Additur is unconstitutional in federal court because it violates the Seventh Amendment. And remember, the Seventh Amendment only applies in federal court. That's why this can be okay in state court. Seventh Amendment does not apply in state court. So additur violates the Seventh Amendment, which means you cannot get it in federal court, but you can get it in state court. All right? Paragraph D, the motion to set aside the judgment. We saw the federal equivalent of that yesterday. Said they've not asked about that. Take a look at that when you get a chance. Not a big deal there. Let's move to the fifth big topic. Hey, it's appellate review. Basic idea. In an unlimited case, we're going to appeal from the Superior Court to the California Court of Appeal. Appeal is to the district of the Court of Appeal to which the county is assigned. So the state's divided up into these geographic courts of appeal. And notice in California it is singular, Court of Appeal, not appeals, but appeal. What's the timing? Again, timing's goofy. Generally, notice of appeal has to be filed in the trial court within 60 days after mailing or service of the notice of entry of judgment, or it's 180 days after entry of judgment if no notice was served. I got to think that's pretty rare. Usually they will give you notice, and it's going to be the 60-day deal. Now, let's move over to page 69. Top of the page, I think exceptionally unlikely. Judgments in limited civil cases and in small claims matters are appealed to the appellate department of the Superior Court. Not a big deal there. Now, folks, final judgment rule, we kind of like this because we saw it on the federal side. Like federal courts, California follows the final judgment rule, so generally one cannot appeal until the merits of the entire action are resolved. Jot in page 34. We saw that yesterday. Page 34. So the final judgment rule is great. It works in federal court, works in state court. There is a minor exception in state court, and I'd put a D in the margin here. I'm not sure this is anything I'd stay up all night worrying about, but if they hit it, it is a minor distinction. Plaintiffs, defendants, D1, D2, the trial court enters summary judgment in favor of the plaintiff against D2. So it takes care of the claim against D2. That would not be a final judgment in federal court because the cause of action by P against D1 is still pending. Remember, you got to wrap up the whole case, and you didn't do that here. In state court, though, it's different on this one. A judgment as to one of several parties is considered a final judgment. It can be appealed. I would jot this in. It is automatically considered final. It is automatically considered final as to that party. It's automatically considered final as to that party. Here, we've wrapped everything up with regard to that one party. Even though it didn't wrap up the whole case, here in state court, you have a right to appeal. It's automatically considered final as to that party. So a distinction in the final judgment rule. Now, we know that the final judgment rule is a severe limitation on going upstairs. We also know there are exceptions that allow you to take interlocutory, non-final review. Look at number 1. By statute, these are appealable. Look at the third one down. An order granting a new trial. An order granting a new trial, you do have a statutory right to appeal that, even though it's not a final judgment, so that's kind of a nice thing. Paragraph 2 about the collateral order rule. I've never seen that tested anywhere. You can read about that. But number 3, the extraordinary writ. Friends, get out the yellow magic marker. I think we got to know about this. California practice is very, very well known for this, and there's one nuance we're going to look for especially. So here it is. Extraordinary writ. If an order is not otherwise appealable, the aggrieved party may seek, now notice there are 2 of these. One is a writ of mandate, and that's exactly what it sounds like. Mandate is to mandate, to compel the lower court to do something that the law requires it to do. Or a writ of prohibition, and that's exactly what it sounds like. That is to prohibit, to stop a lower court from doing something that the law does not allow it to do. Now, friends, this is not technically an appeal. When we're after an extraordinary writ, this is not technically an appeal, and I would tell them that. I would tell them that I know that. This is not technically an appeal. It is an independent proceeding in the appellate court. It is an independent proceeding in the appellate court. So technically, this is not appealing, but it is appellate review. It's an independent proceeding. So you sue a new case altogether, and you sue it in the first instance in the appellate court. You're after one of these writs. Now, it tells us that the writ is issued to an inferior court, just means lower court. So it'll go from the Court of Appeal to the Superior Court. And such a writ is extraordinary, not routine. So what do you got to show? Let's go over to 70 and figure out what you got to show. To get one of these writs is pretty tough, as we would expect. I mean, they're called extraordinary, so they got to be tough to get. They're not called ordinary writs, they're extraordinary writs. So what do you show? It's kind of like an injunction. Take a look. The party seeking the writ must demonstrate. Number 1, she will suffer irreparable harm if the writ is not issued. So that lower court result is just unusually harsh. It's just unusually unfair. Second, the normal route of appeal from final judgment is inadequate. It's not going to protect me if I got to wait till final judgment. And then third, she has a beneficial interest in the outcome of the writ proceeding. Now, folks, this next one is the one we're going to put stars all around, and we're going to hit it with a highlighter, and we're going to call somebody up and tell them about it. This is the one to watch for. When is the extraordinary writ the only way to seek review by an appellate court? It's from denial of a motion to quash service. Denial of a motion to quash service. Now, folks, jot that in, denial of a motion to quash service, and write in page 53. We said this on page 53, and we said we'd see it again. Here it is. If you brought the motion to quash because, let's say, no personal jurisdiction, and it was denied, you cannot wait till final judgment to raise that. You got to raise it in a writ of mandate. And it said that back on page 53. I think that would be a great question, because not only do you have to know about the motion to quash, which we spent a lot of time on, and it's important, back on 53, but you also would have to know the extraordinary writ. That would be a great question, and we're ready for it. We see them together. All right, now we're done with the appeals. There is one topic left. The sixth big topic is preclusion. Preclusion, we've been waiting for it all day. I know, people saying, come on, I want to do res judicata, bring it on. Now, I know what you're really thinking. What you're really thinking is, how long is this? Okay, that's what you're really thinking. Well, I'll tell you what, let's just take a look. Notice, we're on page 70. This goes through 75, but we don't need to do page 75. Page 75 is just a chart, and it shows you the comparisons of the major stuff between state and federal. You can look at that when you feel like it. It should be very helpful to you. So all we got to do is get through 74. That's the deal. Now, preclusion has been a popular topic through the years. They hit it last July. Now, I do not think that rules out preclusion this time. Back in the day, they have hit it on consecutive exams. It certainly is a possibility. I'm always looking for this on California. The basic idea is this, and it's going to be much easier than we make it in law school, I promise. Whenever there's been an earlier case, watch out for these issues. They concern the preclusive effect of a prior judgment on the merits. And the question is whether, it's going to be obvious, the question is whether a judgment already entered. We'll call that case 1. It's not called case 1 because it was filed first. It's because it went to judgment first. So a judgment already entered, we'll call that case 1. Does it preclude litigation of any matters in another case? We'll call that case 2. So folks, got to be obvious. You got case 1, you got case 2. Case 1 has gone to judgment. Case 2 is pending. Does the judgment in case 1 stop us from litigating anything in case 2? Now, important stuff here. If case 2 is in a different court system, federal court or state court, from case 1, which system's law applies regarding claim and issue preclusion? It is the system that decided case 1. It is the system that decided case 1. Folks, this is going to be a great area for a question because it allows them to test federal or California law. So it's the system that decided case 1. Let me show you what I mean. Take a look at this hypo. So case 1 is in federal court, and the judgment's entered. Case 2 is in California state court. What law of claim and issue preclusion does the state court judge use? She uses federal law because case 1 was in the federal system. You use the law of claim preclusion and issue preclusion of the system, federal or state, that decided case 1. Now, last July when they hit this, they did not tell you where the first case was, where the other case was at all. So you basically just had to walk through preclusion stuff. Now, that means that as we go through, we're going to have to contrast federal law and state law. Most of the time, they're going to be the same. Now, take a look. Here is a minor distinction. I think this next point fairly unlikely. Suppose the judgment in case 1 has been appealed, or the time for appealing is not yet expired. Is that judgment entitled to claim or issue preclusion effect? Under federal law, yes. Under federal law, yes. Under California law, no. Under California law, no. So they could have case 1 in a federal court. It is now on appeal. It is still entitled to claim and issue preclusion effect, even though it's on appeal. If case 1 were in state court, that would not be true, because once it's on appeal, it is not entitled to claim or issue preclusion effect under California law. Now, bottom of the page, great stuff. We've always been ready for this, and this is exactly something they hit last summer. Claim and issue preclusion are affirmative defenses, so the defendant should raise them in her answer. How is the issue often presented on the bar exam? Motion for summary judgment. Folks, they love raising it in the motion for summary judgment, and that makes sense. It's easy to do, because if preclusion applies, there is no dispute of fact. There is no dispute of fact. Get a preclusive effect as a matter of law. So they raise it through summary judgment. In fact, last July, it said they move for summary judgment based on preclusion. And they've done it through the years, raising it with summary judgment. That's easy. Because summary judgment, you get it if what? If there's no dispute on a material fact, and there is none here, and you're entitled to judgment as a matter of law. Now, over to 71. There are two preclusive effects possible. One is claim preclusion, also known as res judicata. Those are interchangeable terms. The California courts tend to use the older terminology, res judicata, but I got to tell you, on the bar exam, they tend to call it preclusion. Claim preclusion, most recently hit back in 2009. Great question. This stands for the proposition that you only get to sue on a cause of action or claim once. Cause of action state, claim federal. So if you have a cause of action or claim, you only get one case in which to vindicate all the rights to relief for it. Now, friends, I promise you this is easy. Promise. There are three requirements. Be hyper-mechanical here. Just walk them through. This is going to be easy. Requirement number one, you got to show that case 1 and case 2 were brought by the same claimant against the same defendant. Now, be careful here. Notice, not just that they're the same parties in both cases. They must be the same guy suing the same guy in both cases, and that is going to be obvious. They cannot hide the ball. Both cases have to be the same claimant and the same defendant. Not just the same parties, but same parties in the same configuration. Going to be easy to spot. Number 2, case 1 ended in a valid final judgment on the merits. Let's circle on the merits. You got to have a valid final judgment on the merits. What's that mean? Well, general rule is this. Unless the court said otherwise, which it will not on the bar exam, when it entered the judgment, any judgment is on the merits unless it's based on, let's jot them in, jurisdiction, venue, or indispensable parties. Jurisdiction, venue, or indispensable parties. Any judgment is on the merits for this purpose unless it was based on jurisdiction, venue, or indispensable parties. And friends, that's true even if we litigated nothing. Even if we litigated nothing. When it says on the merits, that does not mean we had to litigate anything. Everything is on the merits unless based on jurisdiction, venue, or indispensable parties, even if we litigated nothing. Now, let me prove that. Question, so is a default judgment on the merits? Absolutely yes. Sure. Sure. Even though you didn't litigate anything, it's on the merits. Folks, they've actually hit that. They've never asked you how to get a default judgment. But they've asked you what the preclusive effect is. Of course it is on the merits because it's not jurisdiction, venue, indispensable parties. How about this one? Is a judgment based upon discovery abuse, is that on the merits? Yes. They're all on the merits unless jurisdiction, venue, or indispensable parties. So that is going to be painfully obvious. They cannot hide the ball on either of those. Now, number 3, you got to show that case 1 and case 2 asserted the same cause of action or claim. Now, here we have a split. And this is the only area where Fed and Cal are going to be different in a major way. Under federal law, claim means transaction or occurrence. T/O, transaction or occurrence. Under federal law, the claim is the transaction or occurrence. So you get one lawsuit for a transaction or occurrence. California is different. And this is important stuff. California law, you get one cause of action for each right invaded. So if a single accident caused both personal injury and property damage, there would be 2 causes of action. One for your body and one for your property. What is this theory called? It is primary rights. This is primary rights. It is a minority view. Very few states follow it, but California is one of them. So primary rights is what we do under California law. Transaction or occurrence is what we do under federal law. Let's put all that together in a hypo. Hypo, case 1, P sues D for personal injuries. I'd circle personal injuries. All we're after there is PI, personal injuries, sustained in an auto collision. A valid final judgment on the merits is entered. We don't care who wins, just so it's entered. Case 2, P sues D for property damage. I would circle property damage. Case number 1 was about PI. Case number 2 is about property damage from the same crash. Should a court enter summary judgment for the defendant in case 2 under the doctrine of claim preclusion? Let's get mechanical. Number 1, were both cases brought by the same claimant against the same defendant? Yes. They were both P versus D. They were both P versus D. That's always going to be obvious. Cannot possibly hide the ball. P versus D, so that's a yes. How about number 2? Did case 1 end in a valid final judgment on the merits? Yes, absolutely. That's clear. So the only tough one is number 3. Did both cases involve the same claim or cause of action? Now let's go to 72, figure this out, because it depends on what law we apply. Did both case 1 and case 2 involve the same claim under federal law? Yes, absolutely. Because both cases involve the same transaction or occurrence. So the court could grant defendant's motion for summary judgment in case 2. You see why? Because plaintiff P sued twice on the same transaction or occurrence. Plaintiff sued twice on the same T/O. Remember, under federal law, the cause of action, the claim is transaction or occurrence. You only get to sue once on that transaction. She's suing twice on the same transaction, therefore summary judgment for the defendant. But under California law, the answer is no. The answer is no. Because the 2 cases involve different primary rights. The 2 cases involve different primary rights. Remember, under California law, the cause of action is not the transaction. It is the right invaded. So you have 2 causes of action in California, one for your body and a different one for your property. So you may sue twice under California law because they're 2 completely different primary rights. And that is how the narrower definition means we're going to get more litigation out of it. Now, how about this next hypo? What if you have a contract case? They've not done this in many, many, many years. Plaintiff and defendant are parties to a contract under which the defendants are required to make monthly payments. When P files case 1, D has failed to make 6 such payments. Under federal and California law, are there 6 separate claims here, or is there only one claim or cause of action? There is one. There is only one here, only one. And here's the rule in contract. The claim is all breaches up to the time of filing suit. The claim is all breaches up to the time of filing suit. So even though you've breached it 6 times, we're filing suit now after the 6th. It is all those breaches up to the time of filing suit is one claim. So there's only one claim here or one cause of action. We're not going to let you sue this guy 6 times over this. You get to sue once. It is all breaches up to the time of filing suit. Now that's claim preclusion, 3 mechanical steps. Next up, issue preclusion. This is also known as collateral estoppel, and those are interchangeable terms. This is narrower. This precludes relitigation of a particular issue. Let's circle the word issue. Our focus is narrow. It's an issue that was litigated and determined before. And that issue is then deemed established in case 2, so we're not going to relitigate it. Folks, always start with res judicata, claim preclusion. If you get claim preclusion, we're going to dismiss case number 2 altogether. But if that does not work, then we think about collateral estoppel or issue preclusion, because that'll take an issue out of the case. If it applies, this issue is not going to be relitigated. Now, this is real mechanical stuff. They hit it last summer. Walk them through. Number 1, you got to show that case 1 ended in a valid final judgment on the merits. We know what that is because we just did it. Same as in claim preclusion. Now it gets different. Number 2, you got to show that the same issue was actually, circle the word actually. We actually litigated and determined this in case 1. Folks, it must be litigated. It must be litigated. Now, they've got to make that clear. Last summer, they made it clear. that this doctor had been sued before for negligence about this. It was litigated. Now, notice what that means in text, and they have actually hit this. So you probably do not get issue preclusion from a default judgment because you probably did not litigate anything. You got claim preclusion from a default because it's on the merits. But here, you must have litigated the issue. They got to make that obvious. Number 3, you got to show that that issue was essential to the judgment in case 1. That means without that issue, the judgment in case 1 would have been different. That's usually going to be obvious. Now, 4 and 5 are the ones where we got to be real careful. This is the one where people get confused. We're not going to get confused. Keep it mechanical. Number 4, against whom. Circle the word against. We're not worried about by whom here. It's against whom. Against whom can preclusion be asserted? Well, only against somebody who was a party to case 1 or represented by a party in case 1 like a class action. Now, folks, look at this. This is required by due process, so that is the same in every court. That's always true. Federal law, California law, every state's law is the same here. You can only use it against somebody who was a party to case 1, okay? Now, step 5, and this is where it gets sexy. Now, by whom? Let's circle the word by, not against. We already did that. Now, by whom is issue preclusion asserted? Traditionally, it could only be by somebody who was a party to case 1. Only such a party to case 1 could use preclusion in case 2. That is called mutuality, but this is not required by due process, so it can be abandoned, and this was an issue last summer. Top of the next page tells us that modern law abandons mutuality in some situations. That's okay because mutuality is not based in due process. Now, this allows, and this is an important phrase, non-mutual issue preclusion. Now, that sounds real hard, but it's not. All that means is preclusion is being asserted by somebody in case 2 who was not a party in case 1. So when you hear non-mutual issue preclusion, all that means is it's being used by somebody in case 2 who was not a party in case 1. Now, friends, there are 2 ways to raise it. They've hit them both. One is non-mutual defensive issue preclusion. Now, that's a mouthful, but we can figure it out. Here's what that means. It is being used by somebody who was not a party in case 1. That's what non-mutual means. And she's the defendant in case 2. That's all that means. Defensive just means she's the defendant in case 2. So, you know, you go to parties, people are always talking non-mutual defensive. Now we know exactly what it means. Okay. Now let's do a hypo with the wonderful cast of Full House. Here we go. DJ, driving Becky's car, is involved in a collision with Joey. Remember Joey Gladstone, kind of a goof. Now, assume that Becky is vicariously liable for DJ's acts. Here's the litigation. Case 1. Joey sues DJ. DJ wins based on a finding. I would circle that word. That is litigated. That is decided. There is a finding that Joey was negligent, and that caused the wreck. The court enters final judgment for DJ. So DJ wins the case. Now, case 2. Joey sues Becky, because after all, Becky's vicariously liable. Can Becky assert issue preclusion as to the finding of Joey's negligence? Think about Becky's situation. She lent her car to DJ. DJ's in a wreck with Joey. Joey sues DJ. It's determined it's all Joey's fault. Now, Joey sues you. You got to say, wait a minute. It's already been determined that you were at fault here. She wants to use collateral estoppel issue preclusion. Can she do it? Let's get mechanical. Number 1. Did case 1 end in a valid final judgment on the merits? Yes. Yes, absolutely. That's always going to be clear. Number 2, was the same issue litigated and determined in case 1? Yes. Joey's negligence. Yes. Joey's negligence. Yeah, we litigated that. We decided that. That's a done deal. 3, was that issue essential to the judgment in case 1? Well, the answer is yes, sure, because that is why DJ won. It is why DJ won. DJ won that case Because Joey was negligent, sure. So that's usually going to be obvious. Now, 4 and 5, keep them straight, very mechanical. Number 4 is issue preclusion, being asserted against somebody who was a party to case 1, yes, against Joey. We're using it against Joey, and he was a party to case 1. So we're not violating due process. We're in good shape. We're 4 for 4. Now, what about number 5, though? But preclusion is being asserted by someone, not against, but by, who was not a party to case 1. Becky was not a party to case 1. Under the mutuality rule, which I would always throw in, you could not do it. But how do we handle this under federal and California law? It is okay if Joey had a full chance to litigate in case 1. It is okay. If Joey had a full chance to litigate in case 1, California law, federal law, allow non-mutual defensive as long as Joey, the guy against whom you're using it, had a full chance to litigate in case 1, which he undoubtedly did. Now, the last step is non-mutual. We know what that means. Offensive issue preclusion. And as it tells us, this means it's being used by one who was not a party in case 1. That's non-mutual. And she's the plaintiff in case 2. That's all offensive means. She's the plaintiff here. Now, same facts. And this is our last hypo. All right? I know it's late. I know you're weary. I know your plans don't include me. Now, here we go. Same facts. Except case number 2 is brought by Becky against Joey. She sues to impose on Joey liability for damage to her car from the wreck that Joey had with DJ. Becky wants to assert collateral estoppel as to the finding in that first case that Joey was negligent. Can she do it? Folks, this is exactly what they hit last summer. And we walk them through. Top of page 74. The first 4 requirements are all met, exactly like in the preceding hypo. It's the same thing. 1 through 4, as above, the first 4 requirements are met. Number 5, the only tough one, is the 5th requirement. Because here, issue preclusion is asserted non-mutually by Becky. She was not a party in case 1. And here, the person using it, Becky, is the plaintiff. Under the mutuality rule, you could never do this. But notice, federal and California law allow this as long as it's fair. As long as it's fair. Now, what does that mean? Folks, this is one of those areas where there's no clear answer. So you throw these in and flip a coin. That's all you got to do. One is that Joey had a full, fair opportunity to litigate in case 1, just like with non-mutual defensive. Second, Joey could foresee multiple suits. You know, when Joey sued DJ in that first case, he knew it was Becky's car. So he knows there's going to be litigation with Becky. So it is fair to say, hey, once you lost to one, you lose to all. The third one, nobody knows what to make of this, but Becky could not have joined easily in case 1. If she could have joined easily in that first case, maybe she should have. Nobody knows exactly what to make of that, but throw it in. The 4th one's probably the most important. There's no inconsistent judgments on the record. So if there had been multiple litigation about this wreck, sometimes Joey's found negligent, sometimes not, then it would be totally unfair to let Becky get issue preclusion on the negligent finding. You cannot simply pick out the one you like. You throw in those fairness factors, flip a coin, tell them whether you think it's fair to use non-mutual offensive. Now, folks, look at this. Let's cut to the chase. Limited time. What is the stuff in this entire course that we should probably focus on? Friends, I'm going to give you the big 8. I think these are the most likely. You never make a prediction, bar review. As a great philosopher, Casey Stengel, once said, it's dangerous to make predictions, especially about the future. So you have to be careful about that. But folks, I think these are the big ticket items. And before we get to them, let me just mention one thing. It is quite normal. It's natural. It's the normal state of affairs to get nervous about the bar exam. And one of the questions I always get is, hey, do I have to know everything in here? Do I have to know everything? No, you don't have to know everything. Nobody knows everything. I'm always very sensitive to this, but even more so lately because my son took a bar exam recently. and he was living with us while he studied for the exam. In fact, he's still living with us, which is great. That's terrific. Now, folks, the deal is, I know you get nervous, and at some point you think, man, this is a drag. I'd rather be the orphan in a Dickens novel than go through this. But folks, keep it in perspective. Nobody knows it all. And what's the worst case scenario? I mean, suppose they ask you something you don't know. Suppose there's something on there you don't know. What are you going to do about that? First of all, you're going to look around the room and say, I'm not alone. Nobody else knows it either. And then the second thing you're going to do is do not let it take you off your game. If there's one thing in there you don't know, nail the other stuff. Come back to that stuff you don't know and make up a rule. What the hell? You know, the deal is, if it's something you don't remember, you just make up a rule. Well, the rule in this case is blah, 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 blah. And then you apply the rule, and you're probably going to get credit for it. Relax about this stuff. But here's the deal. Number one, I don't think there's any doubt. It's PJ. Personal jurisdiction. They're overdue. Put pages 36 to 41. These are the pages in this very handout. So, personal jurisdiction, absolutely overdue. 36 to 41. Number two, federal SMJ. Federal subject matter jurisdiction. Federal SMJ. Pages 1 through 8. That is always something we look for. Federal subject matter 1 through 8. Number three, defendants' responses. Defendants' responses, and here are the page numbers, 14 to 16, 14 to 16, and 50 to 54. 14 to 16 on the federal side, 50 to 54 on the state side. Watch for that state stuff, including that anti-SLAPP stuff and the motion to quash and the general demur. Watch for that. When they go state, I'm looking in that area. Number four, defendant's claims. Defendant's claims. Pages 16, 17, 16 to 17, and 25. 16, 17, and 25, and 54 to 55. And 54 to 55. 16, 17, and 25 are all in federal court. 54, 55, cross complaints in state court. Number five, different pleading standards. Different pleading standards. I'd look at pages 14 and 48 to 50. 14 is all that plausibility stuff in federal court. 48 to 50 is the facts constituting cause of action, and also that fictitious defendants. I'd watch for that in terms of pleading stuff. Number six, our friend, the class action. The class action. Pages 27, 28, and 61, 62. 27, 28 in federal court, 61, 62 in state court. Number seven, trial and motions. Trial and motions. Remember the JMOL, the directed verdict, all that stuff. Pages 32 to 34, 32 to 34, and 65 to 68. 32 to 34 and 65 to 68. And number 8, I still think it's there, even though they hit it last summer. Preclusion. I'm always looking preclusion. Preclusion, 70 to 74. Always watch for that as well. Now, friends, the very last point. I promise this is it. If you have any questions, call me. Email's not a good option, so please call. And if I'm not there, and friends, I will not be there, because this is my office number, and I'm there office hours, like 9 to 10 every 15 Thursday, something like that. So leave your question, leave your phone number, I'll call you back. And my phone number is 404-727-6838. 404-727-6838. I wish you the very best of luck. Thank you.